Good afternoon, everyone, and welcome to the Senate Judiciary Committee's hearing dated 1/12/2022. We're going to start the day by opening the public hearing on Senate Bill 303, and we will call the prime sponsor, Senator Hennessy. Good afternoon, Senator, and welcome to the committee.
Good afternoon, Chair Carson and members of the committee. I appreciate you taking the time to hear this bill, especially you, Senator French. My name is Erin Hennessy. I am the state senator for District 1. The New Hampshire Sheriff Association asked me to bring this bill forward. The sheriffs are handling prisoners, custody and control, transporting them, and staying with them in their hearings in the courthouses across the state. They are currently reimbursed about half of what the current per diem court security officers are paid, and this bill would raise their pay to equal what the court security officers are paid. Sheriff Dominic Ricciardi is here to testify in favor of the bill and will be able to answer any questions that you may have. Do you have any questions for me?
Thank you very much for your testimony, Senator. Are there any questions? Senator Khan.
Thank you, Madam Chair, and thank you, Senator, for your testimony and taking this question. Were you surprised by the fiscal note, the additional cost that there's associated with this?
Was I surprised by the fiscal note? So yes, we're actually working on the fiscal note because we believe that there might be, it might be incorrect. But we did not have that information today since this is not the Finance Committee. So if you want to ask questions about that, I will happily get that information to you.
Okay. Do you know,
Yes.
you know the amount that we spent in the current year, what's appropriated?
Sorry, I didn't hear your question.
Do you know the amount that's appropriated for this current fiscal year?
Yes, $772,500.
Thank you.
Are there any further questions for Senator Hennessy? Okay. Seeing none, thank you very much, Senator.
Thank you.
Senator French, could you close the door, please? Okay. Next, we are going to hear from Richard Head.
Senator, can I provide a handout?
Yes, please, hand it to our committee secretary, please. Thank you.
Need more? Good afternoon. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We do not have a position on this bill and have no negative input. The issue is purely one of making sure there's sufficient funds available to pay for the increased cost. Just quickly, by way of background, the Judicial Branch has for some time been funding the sheriffs to provide court security in the superior courts. And every biennium in House Bill 2, there are usually two provisions regarding salary for sheriffs to provide security. One is at a fixed statutory rate, and House Bill 2 in 2021 provided for court security at $80 for a full day, $40 for a half day. And then separately, Section 91:18 in House Bill 2 provided that for the biennium ending June 30th, 2023, the state shall reimburse sheriffs at the rate provided in the collective bargaining agreement. So for some time, we have for court security, and the superior court's been reimbursing the sheriffs at the same rate we pay the court security officers under the collective bargaining agreement. For the first time in House Bill 2 in 2021, the cost for essentially transport and custody and control of prisoners was shifted from the executive branch to the judicial branch. So this is the first year that the judicial branch has been reimbursing sheriffs for the transport and custody and control of prisoners. That again, in House Bill 2, was set at a statutory fixed rate for half-days and full days. But for prisoner custody and control, there was not a similar provision, which has existed for years, for court security. So there was no provision in House Bill 2 to do what this bill is attempting to do, which would provide for transport and custody and control at the CBA rate that we pay the court security officers. So that's fine. But as the testimony was, House Bill 2 was based upon the fixed rates, not these increased rates under the collective bargaining agreement. So the calculation in House Bill 2 was based upon fixed rates for half-day, fixed rates for a full day. This would increase by approximately, I don't know if it's double, I actually don't know the differential, to tell you the truth, and I apologize. But we did have our financial staff calculate, and essentially we have to estimate, because these are reimbursements for estimated future services. But what I handed out was our fiscal note worksheet, and I handed that out only because I know the fiscal note says that the cost is indeterminable. And in talking with Mike Hoffman, that makes sense because we are only estimating going forward. We don't have a dollar certain going forward in terms of our estimate. So we did sort of base it upon history that we've obtained from the Department of Administrative Services, who used to fund this. So we don't have a long experience with these payments. And our financial folks put together an estimate by county that's outlined in the fiscal note worksheet. And by doing that, we estimated that there would be an increased cost of approximately $433,000 a year in order to pay at these higher rates. And at some level, it makes it simpler because it's the same rate that we pay for court security. It's the same rate we pay for our CSOs. It is simply a budgetary issue because House Bill 2 was at a fixed half-day and full-day rate. It did not account for the differential. And with that, I'd be happy to take any questions.
Thank you very much for your testimony this afternoon. Senator Gannon has a
Just
question.
really easy question. So you said about double, 80 for a full day, 40 for half before. We're doubling it, so now you're looking at 160 or 80 for a half day.
You know, truthfully, the 80 and 40, I forgot to write it down. The 80 and 40 was the fixed rate for court security,
Yeah.
which House Bill 2 did account for and put it into the collective bargaining. I didn't write down what,
You had said double, so I'm just figuring, so ballpark,
Give or
I just
take,
went
sure.
down. So $20 an hour is what we're doing, which seems like a
I
deal to
think
me.
it's actually 20, it's roughly.
Somewhere around
We'll
there.
give it a rough $20 an hour.
Sounds like a deal at any cost.
That's about
Thank
right.
you.
Are there any further questions? Senator French?
Thank you, Madam Chair. Just to clarify, is a full day 8 hours?
You may check with the sheriffs on that. I don't know if they calculated a 7.5 or 8.
Well,
I don't know the
it's
answer to
right
that.
in that range.
I would assume so, yeah.
So right now, it's less than McDonald's employees make?
In terms of the fixed rate, it's not good.
Yeah, thank you.
Are there any further questions from the committee? Okay, seeing none, thank you very much.
Thank you.
Next, we're going to go to Dominic Ricciardi. Good afternoon.
Good afternoon. Good afternoon, Chairwoman Carson and members of the committee. My name is Dominic Ricciardi. I'm High Sheriff of Carroll County and the current president of the New Hampshire Sheriff's Association. The New Hampshire Sheriff's Association asked Senator Hennessy to bring forward this bill, and I am here to testify in support of that bill. The custody and control of prisoners during transport and inside the courthouse can be a dangerous one, and we are asking for the reimbursement to equal what the court security officers are currently being paid. The language in the bill would reimburse, quote, at the rates provided in the collective bargaining agreement applicable to per diem court security officers employed by the judicial branch for court security to attend any official business, unquote. The current rate is $65 for a full day and $35 for a half a day. We, the sheriffs, are finding it harder and harder to recruit qualified candidates for this position. We need to be able to pay a fair wage for doing this work, so the reimbursement should be at least equal to what the other court officers are being reimbursed currently. We respectfully ask for you to find this bill ought to pass, and thank you for your consideration, and I can answer any questions that you may have.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Next, we're going to go to Thomas White.
I'm for 304.
Oh, so you signed up from the wrong bill. Okay, not a
I
problem.
prefer to 304.
Okay, thank you very much. Yes,
Mr. White, you might wish to make sure that you're on 304.
yes, I would suggest you do that. Are there any other members of the public that would like to speak to Senate Bill 303? Okay, seeing none, I will close the public hearing. Okey-doke.
We'll save it for the next bill.
Going to open the public hearing on Senate Bill 375 FN and recognize the prime sponsor, Senator Gannon.
Thank you, Senator Carson. We visited yesterday donors in a similar bill, but this is a little bit different. This is the Charity Protection Act, and what we're trying to do is prohibit a state agency or officials from imposing filing or importing fees that are onerous, that they're unduly burdensome and more stringent than what the federal law or the state laws have. These charity groups, I don't want anyone who's doing work for education or other groups, I don't want to have a financial burden, the time burden when they have to, if they provide all the paperwork as required under the law, both federal and state, any more time you're taking away from the purpose of the organization, which is to help people. Senator Khan, you'd probably have an objection with if I became an AG. I probably am more of a partisan senator than some on many issues, and you might then fear me on, I could be unduly burdensome on groups that I might have slight edge against, an ACL group, a Planned Parenthood group. Not that I wouldn't be trying to be fair, but across the country we've had several examples of states which have unduly burdened. In Connecticut, there's an educational nonprofit in Kessel versus Siegel. In Massachusetts, they've been going after more extensive reports than the state requires or the federal government. Have been having the same problem in Michigan, New Jersey, and Oregon. So why is this? I think you asked me a few months ago, why did I file this bill? I don't know if we ever talked about it. Why is it necessary? The good woman from the Philanthropy Roundtable answered it best yesterday. She said, and I wish I had thought of it, but I didn't, you don't want to need it, but if you need it and don't have it, these organizations will work with the charitable trust gentlemen behind me with any concerns they may have to ensure that they can effectively do their job. If they need more information, there's already avenues, if there's fraud being committed, that they can go investigate. So we're not going to, they brought up a case yesterday of a cancer group, and they needed a donor list. And so we don't want to stop them if there's fraud going on or something. Those people need to be vetted and sorted out. But we don't want to unduly burden charities. And I would take any questions, and there are people coming after me who are probably more knowledgeable on the topic than myself, but I would entertain questions. Thank you.
Thank you very much for your testimony, Senator. Are there any questions from the committee? Senator Khan.
I would. Thank you, Madam Chair, and thank you, Senator, for bringing this forward. I've had constituents raise questions about some of the filings that are required in Chapter 7 as well. And I'm wondering if you've had any specifics about the additional burdens that some of the charitable organizations face.
Again, I will let the attorney from Philanthropy Roundtable, this is what she deals with, it's in her wheelhouse. I could give you examples that I've only took a cursory look at some of these, the case law. They have extensive knowledge, so you know what my feelings are on the bill. I'd rather them go into detail, if that's okay with you.
Would you, may I?
Follow up?
Would you believe that some constituents that I have worked with feel that some of the financial audits that are required of smaller charities, those that bring in maybe $1 million and have to pay about $15,000 for that audit, feel that that is a burdensome requirement for them as opposed to a charity that might bring in $5 million and it'd be like
Sure, I see where you're talking about, I understand, and yeah, and again, it's not really a political bill because it works both ways. But yeah, the burden on smaller charities is obviously going to be a much greater financial impact on them. So I would believe that you've run into this situation.
Thank you, Ms.
Are there any further questions from the committee? Seeing none, thank you very much, Senator. Next, we're going to have Tom Donovan, and I believe you have Diane Quinlan with you. So just make sure you're coming up together to identify yourself when you testify. Good afternoon.
Good afternoon, Madam Chair and Senators. We're back again. We'll try not to cover the same ground that we covered yesterday. This bill is different from the one yesterday. The bill yesterday was, I think we talked mostly about donors, and there may be some language we can work on with respect to donors there. We think part of the issue from yesterday was that it wasn't limited to donors. It also would cover directors and certain corporate members and things like that. This bill is focused really at the charitable trust unit, and it talks about no reporting requirements unless they are set forth in our statute. Senator Gannon mentioned fees. Our fees are set in statute. We're not allowed to charge any more or any less than what's in the statute, and those fees haven't been raised since, I think, the early 90s, and we are self-funded, so we don't take any general fund dollars for what we do. So from those fees, thank you very much. As Senator Gannon mentioned, this bill doesn't prevent us from doing fraud investigations or enforcement actions, and we do that and continue to do so. And as Diane Quinlan mentioned, we recently conducted that breast cancer charity fraud enforcement action. But there are things that we do that are short of that. that involve regulation of charities, and it relates to the origin of the charitable trust unit. New Hampshire was the first state to start one back in 1943, and we're proud of that fact. The Attorney General has always had oversight authority over charities. Dates back since the beginning of the state of New Hampshire. We have cases that are from our Supreme Court that are 200 years old, dealing with charities, and the Attorney General is involved in them. Yeah, it goes all the way back to ancient England and Queen Elizabeth I, and I'm not going to bore you with all that. But the reason I mention it is that just because something isn't specifically stated in RSA 7, which talks about the charitable trust unit, doesn't mean it's something that the Attorney General should have some oversight over with respect to a charity. And let me give you a couple of examples. Towns hold charitable funds. You all know about your trustees of trust funds. And sometimes they don't have to file the annual reports in the same way the charities do. They file something with the DRA for tax rate setting purposes. But sometimes we hear about or get questions about perhaps improper spending or improper investing by town trustees of trust funds. We may require the towns to report to us about that. And again, we don't want to cause expense by opening a formal investigation. But that's the sort of thing that we do as part of our common law authority, because we want to make sure that Mrs. Jones, who left a scholarship fund in 1890 for the children of, let's say, Deerfield, that income is still being used today. And that is all under our common law authority. Similarly, churches are exempt from reporting to us. However, we do get cases where if Mr. Smith left money for flowers in a church, left $100,000, income only to be used for flowers in the church. If the church decides it needs a new furnace and we get word that they want to use that money for a new furnace, well, Mr. Smith's been dead for 100 years. Who's going to enforce it? We're the ones who, we aren't going to bring a lawsuit, but we're going to, if we find out about it, we're going to require some reporting about that. Not in the statute, part of our common law oversight authority. So those are examples, and there are many others. And our fear with this statute is that we're going to be so pigeonholed to what's laid out in RSA 7 that there are so many matters where donors who left money for charitable purposes, they are not going to have those purposes fulfilled long after they're dead. So if we want to encourage charitable giving, you do so in part by a person having confidence that 50, 100 years from now, the Attorney General is there to make sure that the gift that I left in trust will be used for that purpose forever. Diane and I were in the New Hampshire Supreme Court a couple of years ago over a trust for Mary Baker Eddy. Mrs. Eddy was the founder of the Christian Science Church, a resident of New Hampshire. She died in 1910. There was a discussion about one of her trusts. And we took the position in that case, looking out for what Mrs. Eddy's intent was with the dollars that she left with respect to that trust. So that's a part of our work, not in our statute, but we think it's part of an important part in common law and in statute. Thank you.
Good afternoon, Madam Chair and members of the committee. My name is Diane Quinlan, and I am the Assistant Director of Charitable Trusts at the Attorney General's Office. The purpose of Senate Bill 375 purportedly is to minimize burdens on the charitable sector with respect to reporting requirements. But our state statute already ensures that the charitable sector is not burdened by the annual report requirements. RSA 728(3) provides that annual reports shall not unreasonably add to the expense of the administration of charitable trusts. So that's already in our statute. State law also allows the Attorney General to suspend the filing of reports as to particular charitable trusts when it becomes a financial burden. And we've done that as well a number of times. Moreover, our filing requirements do not impose burdens on charities. The most significant piece of an annual report is the financial report. For charities that file Forms 990 with the IRS, we just ask for a copy of that Form 990. For smaller charities that don't file Forms 990, we've developed a very simple financial form that's significantly easier than anything that they would file with the IRS. In the last year, we actually revised our annual report forms with input from the charitable sector. We consulted with the New Hampshire Center for Nonprofits, accountants that work with charities, and other representatives of the charitable sector to simplify our forms and clarify our reporting requirements. We also, in the last year, established an online filing process for our annual reports. There are written instructions, there's a video on how to complete the report to make it much easier for charities to meet their annual report filing requirements. In the last year, we've received many compliments from multi-state filers about how easy it is to file annual reports with our state. So we're very proud of that. Now, the bill does say that it won't prohibit the Attorney General from adopting rules pertaining to charitable trusts, but as Tom pointed out, rules and regulations cannot possibly address all the circumstances under which we require information from charitable organizations in order to do our jobs. And for these reasons, we respectfully urge you to report Senate Bill 375 as inexpedient to legislate. We're happy to answer any of your questions.
Thank you very much for your testimony. I was just looking up the RSA. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you for that, for your testimony. I am familiar with the situation you described where there has been charitable giving way in the past. I live in Hopkinton, and we had a building that was given to the town long ago for a certain purpose. The purpose has changed, but when the town tried to sell the building, you can imagine that there was outcry from folks for all different reasons. So my understanding from your testimony is that if this bill passes, and I believe that the Charitable Trust Unit did provide some guidance or intervention in this case, but my understanding is that if this bill passed, you would not be able to do that in the future for similar issues. Is that correct?
That's correct, Your Honor. We could only bring it for an enforcement action after, that's correct.
Yeah, follow up?
Yes.
Yeah, and I will say that the issue was resolved, and I think, do you think that if you weren't able to intervene, provide some guidance, that those issues would get further along, potential involve costly litigation? Could you see that down the road if this bill passed?
Yes, I believe that was the former town library.
Yes.
Yes, and it would get more, exactly right. We know that problems involving municipal properties that have a donor restriction on them, and there are in many towns, unless you deal with it early, property will get sold, people will get sued, and it will get very expensive.
Yeah, thank you. Thank you.
Senator Gannon has a question.
Thanks. Just a quick question, and you made it nice and simple. Your flower example, wouldn't that go under Section 2, would be a fraud investigation, and this bill wouldn't restrict it because that would be more of a misuse of funds. So you'd be allowed to go after that still. So I didn't see where you were on point. And your flower example that you gave?
Yeah, flowers for the church.
So I'm thinking even with this bill, you'd still be able to do that under a fraud investigation.
We would, Senator, we would not want to get to that point of a fraud investigation. In other words, with that kind of situation, what we would do is we would contact the church and talk to them about their responsibilities to ensure that they comply with the donor's wishes. To the extent that they can't, we would work with them to petition for cypre with the court. But we wouldn't want to get to the point of enforcement action, which becomes very expensive for the charity, and in this case, a church.
Thank you.
Are there any further questions? Okay. Senator Khan, see, that's why I can see you.
Easy, easy. Thank you, Madam Chair. Mr. Sullivan, if you'd consider, I see the bill as being fairly expansive and would understand why you might have concerns and your recommendation on this. But I'm also wondering if there are particular carve-outs here where there are established federal guidelines that are significant for charities, like a Form 990, which is a financial reporting form, which I assume is what you've simplified by allowing charities to put that information into your database and submit it, which is great. The additional burdens, though, that charitable organizations face come with additional requirements, which only the legislature can influence by changing statute. And in particular, the filing requirement of an audit on particular charities that may be small, maybe were considered large in 2004 when the statute was written, and today don't seem quite so large 16 years, 17, 18 years later. So would you consider that if this bill became more customized, if Senator Gannon would want to work together, I'd be interested in working with him on that. Are those the kinds of things that you would want to help participate in that kind of conversation?
So, Senator, we're always willing to have a conversation, absolutely. I think the bill from yesterday with respect to donors is something that's a little more concrete, that is easier for us to work with than this. On your audit question, I recall, Senator, you had a bill that didn't pass with respect to, so right now the law is that if a charity has revenue of more than $1 million, they have to submit an audit. Your bill proposed to raise it to $3 million. We thought that was kind of high. I think there's room somewhere that's more reflective of the cost of living since that was passed, and yeah, absolutely, that's the sort of, but that could be a targeted bill with respect to raising the limit for audits. And that's certainly something that could be looked at. Yes.
Thank you.
Are there any further questions for Mr. Donovan or Ms. Quinlan? Seeing none, thank you both very much.
Thank you.
Chair will call Kathleen Reardon. Good afternoon.
Thank you, Madam Chair and members of the committee. My name is Kathleen Reardon. I'm the CEO of the New Hampshire Center for Nonprofit, a statewide organization with 700 members representing nonprofits. Our mission is to strengthen and give voice to the nonprofit sector and provide learning opportunities. As I had discussed yesterday in front of this committee, we do have concerns about hampering reasonable regulation and transparency amongst the nonprofit sector. And that's why we're opposed to SB 375. We really don't think that this proposal is needed. As the Charitable Trust Unit has just testified, they have had a long history of reasonable restraint in appropriate filing requirements. They've never required the donor list in Schedule B that we talked about yesterday. Their annual report is easily available online. It is reasonable and doesn't create a significant burden on nonprofit leaders. The Charitable sector does value its privacy, but also recognize that there is an important public trust and values that transparency and accountability that these annual reports do allow. New Hampshire's does rely on its nonprofit sector, and they rely on the sector not only for providing essential services and supporting people in need, but also they expect nonprofits to manage their finances well, to have transparent governance, and to avoid self-dealings. And so some of this annual report requirement is part of what we believe is important for the sector. Furthermore, I think that the partnership between government and nonprofits, we've seen that time and time again, and especially since the pandemic. And so this is not the time that we would want to restrain our government agencies, making sure we're really working together in partnership. So if there are, again, thank you for allowing me to testify, and I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions? Senator Khan.
Thank you, Madam Chair. Ms. Reardon, if you'd consider, if this bill became more targeted, focused perhaps on financial reporting requirements of smaller charities as opposed to larger ones, is there something in there that you, as the leader of this very large organization representing nonprofits, would you support that?
I'd have to understand. I'd certainly look at it. I'd have to understand what that looked like.
If I can continue, if that was a bill that limited audits for charitable organizations, requiring it for organizations perhaps that had annual revenues of $2 million or more, but lessening it for those that had revenues of less than $2 million, is that something that your organization would support?
I think what I would say that the organization supports is that balance between transparency and burdensome. So again, without seeing the details of that, I think that it is maintaining that balance. I think right now, while there may be some changes over time in terms of size of organization, the issues with this bill are much more expansive. So I just can really speak to this bill. But, I think what you pointed out is that there is a balance to that transparency and accountability.
And if I might, and the cost that's related to that transparency?
Right.
Thank you.
Are there any further questions? Okay. Seeing none, thank you very much for your testimony.
Thank you.
The chair will call Elizabeth McGuinnen.
Great. Thank you, Chairman Carson and members of the committee. I appreciate the opportunity to speak today in support of Senate Bill 375. My name is Elizabeth McGuigan. I'm Director of Policy for the Philanthropy Roundtable. So the Roundtable is America's leading network of charitable donors working to foster excellence in philanthropy and to protect philanthropic freedom. Our more than 600 members include individual givers, family foundations, and community foundations located in New Hampshire and around the country. So New Hampshire is home to nearly 700 foundations that grant millions to charitable causes each year. The state's future will be brighter if it continues to foster such a friendly environment for private charitable organizations to meet the needs of its citizens and solve pressing social challenges. So the Charity Protection Act allows New Hampshire's philanthropic organizations to fulfill their missions without the fear of future government overreach. The bill calls for any new requirements on 501c3 corporations to first be deliberated and approved by the legislature, excluding regulations for charitable trusts. Under New Hampshire statute, this protects private foundations and charitable organizations and ensures that the state's Department of Justice still maintains full authority over regulations for charitable trusts, charitable sales, promotions, and solicitations. This is a common sense reform that honors the transparency of the legislative process, as well as your roles as duly elected representatives. So S 375 allows New Hampshire's charities to focus on advancing their missions rather than on complying with increased government mandates. Now, we've heard the Department of Justice expressed concerns that this bill would hinder the office's ability to properly regulate the charitable sector. And we are certainly open to an amendment to address their concerns. We provided this content of this legislation to their office earlier this fall. We're open to working together. Our goal is to narrowly tailor an amendment to ensure that the department does have full authority to continue the good work they do to appropriately oversee the state's charities. The bill as it stands explicitly states that it does not apply to what's already authorized under New Hampshire statute. It does not limit communications or investigations. It explicitly limits annual filing and reporting requirements only. And if there are regulations that could be authorized and imposed under existing law, they would still be allowed under S-375. The bill explicitly exempts investigations of fraud and enforcement, and donor intent investigations, as we heard about, are not covered by this bill, nor are charitable trusts in general. The change here would be if a future regulator were to overstep current authorizations and seek new annual filing or reporting requirements that are not authorized under current law without going through the legislative process. And so this is a proactive, protective bill that sends a signal to charities that New Hampshire will not overreach in the future and values the strength of its charitable sector. So why pass this bill if it's not currently a problem with regulatory overreach in New Hampshire? The short answer is, as I said yesterday, if overreach becomes a problem in New Hampshire, under future officials, it will be too late to address through simple, proactive legislation. This bill offers a predictable landscape moving forward in a time where regulators across the country have become increasingly politicized. Nationwide, we see charitable organizations increasingly face calls to disclose more and more details about operations, governance, and grant-making that do not improve organizational effectiveness, but increase operational and compliance costs. Some states require nonprofit corporations to complete forms with multiple agencies that often ask repetitive and sometimes invasive information. While there are no social benefits to these new requirements, they do divert funding away from charitable giving. What this bill does is aligns New Hampshire's governance of charitable corporations with existing state and federal law unless the New Hampshire legislature determines that it's necessary to enact changes. This reduces the potential for unelected officials to impose more stringent operating requirements, thereby increasing operational and compliance costs on tax-exempt organizations. Philanthropy can and should be a vital part of our communities. We've all seen the good work that charitable organizations have done during this pandemic. The Charity Protection Act will help protect New Hampshire's charitable sector and send a proactive message to charities that New Hampshire is pro-philanthropy and that it values their contributions to local communities. Thank you for your consideration and your time today. I'm happy to answer any questions.
Thank you very much for your testimony. Are there any questions from the committee? Okay, I don't see any. Thank you very much.
Thank you.
Are there any other members of the public that would like to speak to Senate Bill 375? Okay, seeing none, we'll close the public hearing.
Tell me her name.
Senator French,
Yes.
you're up next. Thank you. Okay, oh, no, he's already on here. Okay. Yeah, I asked him to, Senator Khan, we're gonna get started again, okay? I think we'll probably take a 5-minute break before 3:04, just for Jenny to get caught up with everything. Okay. Going to open the public hearing on Senate Bill 301 FN Local and recognize the prime sponsor, Senator French.
Thank you, Madam Chair. For the record, my name's Harold French, Senator from District 7. I'm here to introduce Senate Bill 301. This bill establishes a procedure on filing petitions under RSA 91A with the Superior Court for further relief and investigation. As 91A reads now, it does not spell out the procedures to be used when litigating a request under the right to know law. This bill will address that. We have people behind me that will go over all the aspects of what this bill will do. Thank you.
Thank you very much, Senator. Are there any questions? Senator Whitley.
Thank you, Madam Chair, and thank you, Senator, for taking my question. So, were you able to read the testimony from the ACLU on your bill?
Yes.
Okay, they made a suggestion at the end in support of the bill. And the support was based on the fact that the bill actually, just puts in statute where we are with common law. And they made one suggestion to add one more provision that is also consistent with case law. Are you amenable to that amendment as a friendly amendment?
I did not look at that in depth.
Okay.
But it's a possibility.
Okay, thanks.
Okay, are there any further questions for Senator French? Okay, seeing none. Thank you very much, Senator.
Thank you, Madam Chair.
Next, we're going to call Richard Head.
Thank you, Madam Chair, members of the committee. My name is Richard Head. I'm the Government Affairs Coordinator for the Judicial Branch. We do not have a position relative to the policy on this bill. We do have some thoughts and concerns relative to the structure and the way it's laid out. We'd be happy to work with Senator French and Attorney Lehman in terms of the specifics of some of these. But in general, the bill describes that it applies to all petitions and appeals from 91A, but the content of the bill is very specific relative to document requests. It doesn't apply to sort of the issues of whether or not a hearing was proper or a meeting was properly noticed, or whether it went into non-public meeting inappropriately. All of the procedures that are laid out here are very specific to document requests. So there's just an ambiguity from the court's perspective as to which types of appeals this would apply to. I suspect it applies to document requests, and we would suggest that on line 4, that it be limited to petitions filed to challenge a public body's response to a record request under 91A4. In addition, lines 5 through 6 require a petitioner to file all communications and governmental records provided by the governmental body or agency as an exhibit to the complaint. And the problem with that, of course, so I was at the Attorney General's office. There was once a record request for about 10 different complete copies of homicide files. There are boxes and boxes and boxes of documents, and if the requirement under this provision is every communication and record received has to be filed with the complaint, we're talking about an immense volume of records. And really the appeals of these rarely have to do with the records received. It's the records not received that tends to be the issue. So we're sort of clogging up our system. We don't actually have a mechanism for receiving that type of an exhibit with a complaint. We don't have a particular problem if eventually those documents have to be filed. We ask that they be filed after the petition, after the complaint is filed, after notice goes to the parties, because with that note, it just doesn't make sense in terms of procedurally. And also, I think you're asking parties to take on a significant burden by filing all of the records, which may or may not be in electronic form, and file them with a complaint, which ultimately may not be at all relevant to their issue. With regard to overall, those are sort of the bigger issues we have. happy to work with Senator French, happy to work with Attorney Lehman in terms of the specifics and language going forward. Thank you. I'd be happy to take any questions.
Thank you very much, Mr. Head. Are there any questions from the committee? Senator French.
Just thank you very much for being willing to work on this and get it right. I appreciate that.
Happy to. Thank you, Senator.
Thank you.
Are there any further questions? Seeing none, thank you very much.
Thank you. Thank you.
The chair will call Margaret Burns.
Good afternoon. While I attempt to get my mask unhooked from my earring, I'm Margaret Burns with the New Hampshire Municipal Association.
We feel for you.
And I'll just leave it hanging. How about that?
There you go.
NHMA does not have a position on the bill, but we do have some thoughts and concerns similar to Attorney Head's testimony previously. I think there are some things that could be adjusted to make the bill clearer. Overall, paragraphs 1 and 2 actually seem to be a positive addition to the process for right-to-know law claims. It clarifies what must be in a petition for it to move forward, and it essentially puts the court, the judge, in the position of a gatekeeper to determine what claims should move forward and have stated a sufficient claim, and what claims potentially are frivolous or are not putting forward the type of information that's needed for the claim to proceed. However, we're a little concerned about the standard included in paragraph 2 for the respondent to meet its burden. Specifically, paragraph C, subparagraph C, I'm not sure what the permissible uses terminology means or refers to, so that would need to be clarified what that standard is. Additionally, in paragraph B, and it may be a misreading of the bill, but it seems to me that paragraph B should actually say that that they did a search and it did include documents that are properly exempted, not that they did a search and it did not include documents that are properly exempted. But that may just be some clarity needed in the wording to make sure it's clear exactly what that means. Paragraph 4, I would suggest that it's a little bit ambiguous as far as does the judge get to simply rule on the pleadings without a trial? It's very crucial that in these cases where there is a sufficient claim to move forward with, that an adjudicatory hearing or a trial take place both for the plaintiff and for the defendant in order to be able to submit more evidence. So we would be concerned if this standard were essentially creating a trial on the pleadings kind of scenario rather than allowing for the adjudicatory hearing. Finally, which was echoed in the testimony that took place right before me, the title of the section is A Procedure on Petitions to the Superior Court under this chapter, which means technically it would apply to all claims brought under 91A. However, the substance of the legislation itself clearly applies only to claims brought for alleged violations of records requests, not for alleged violations of meetings protocol, non-public sessions, or items that do not relate to records requests. So it would be crucial for this section to be clarified that it is a process for the procedure on claims relative to records requests and not meetings and non-public sessions and other things that fall under that section. So those are my comments on the bill, and of course I'm happy to take any questions.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you very much, Ms. Burns. Are there any other members of the public that would like to speak to Senate Bill 301? Okay, seeing none, we're going to close the public hearing. And the committee is going to be in recess until 5 minutes after 2. Would everyone please take their seats? I'm going to open the public hearing on Senate Bill 304. And before I recognize the prime sponsor, our own Senator Jay Kahn, just a couple things that I'd just like to talk with you about. As you know, there's a great number of people here that would like to testify on this bill. And we have a policy here that everyone will have an opportunity to testify. I'd like you to be aware of the time that we have to be out of here by 4:30, and we do have another bill to hear after this bill. And I want to ensure that every person who wants to speak has the opportunity to speak. So I'm going to ask you, first of all, if you have written testimony, do not read your testimony. Paraphrase it. Hand your testimony over to our committee secretary. She is going to make copies of it for all of us. We are not execing this bill today, so we are going to have plenty of opportunity to read your testimony. Second of all, please do not repeat testimony we have already heard. We want to hear new ideas, new thoughts. Second of all, please, no clapping, no cheering, no booing. Please don't make faces. If you disagree with what someone else has to say, we can see you, and now the public can see you as well. So please behave with some decorum. If you don't, we have security in the room. We will ask you to leave. So how we're going to do this, we always have a protocol. We recognize the prime sponsor as well as any Senate members that are here. Then we move to state representatives, and then we start going through everyone else. What I'm going to do is when I call a person's name, I will also call the name of the individual who's going to speak next. So that way our staff that's here in the back of the room will be able to go out into the hallway and get that person and have them ready to go. And that's how we're going to work our way through this as well. I'm going to ask you, after you testify, if you can leave the room so that way it frees up a chair for someone who would like to come in. Are we all clear? Everyone understands? Okay, great. So I've already opened Senate Bill 304, and I'm going to recognize the prime sponsor, our own Senator Kahn.
Thank you, Madam Chair. For the record, I'm Jay Kahn, State Senator in District 10, representing most of Cheshire County. The only way that the granted state can fully realize the benefits minority group individuals have to offer is for the majority or dominant group individuals to be open to understanding how past events continue to have an impact on how we engage with each other. The only way for something to change for the minority is for behaviors and attitudes to change for the majority of the population to recognize that they exist and to want to change them. For example, a key factor that changed public opinion of anti-Semitic behavior and sentiment against Jews was when the Catholic Church confronted its anti-Semitism during the Vatican II Council, and in 1965 recognized that Christian anti-Semitism had contributed to the Holocaust. And most mainline Christian churches have spoken out against anti-Semitism. If 1 in 4 New Hampshire women and 1 in 20 New Hampshire men has been the victim of an attempted or completed rape in their lifetime, harassment and violence are prevalent, inherently wrong, and can't be tolerated. And is sexual harassment training a divisive concept? Is teaching or training about our differences so divisive that we need laws to say that we need to treat everyone without regard to their differences? Do the anti-discrimination statutes make us a more inclusive body? Are we increasing our understanding of people who are different from us? We can't confront issues of difference and bias without the discomfort that comes with it. The anti-discrimination statutes in RSA chapters 354 and 193 are ambiguous, and confusing, as if by design. Consider the triple negative in 354A31. I'm going to paraphrase, but borrowing only words from the statute. No public employer or government program shall teach that any person cannot attempt to treat others equally and without regard to differences. Does it mean we should teach without regard to age, sex, gender identities, sexual identity, race, color, marital status, mental or physical disability? And the fact is, people are treated differently all the time on the basis of race, sex, gender identity, religious affiliation. The list goes on. If you are 18, under 18, you can't vote. You can't attend certain movies. If you're under 25, renting a car becomes exponentially more difficult. If you're a woman working in America, you're likely to earn only 84% of what your male counterparts are earning due to gender-based pay gaps. If you're transgendered, you're 4 times more likely to be a victim of violent crime than you are if you're cisgendered. These are just facts and statistics. But do we stop talking about them because they may imply that there's a system that exists that advantages some and disadvantages others? How do we address these very real issues without having the necessary conversations about why these discrepancies exist? In schools, students with disabilities, who, by the way, account for 15% of all public school students, those students with disabilities are treated differently from other students through individualized education plans. And these plans are crucial to ensure that students receive an adequate education in a way that best caters to their specific needs. There's a mathematical statistics method called discriminant analysis, used to assign traits to one group among a number of known groups. It can be used to show how income, educational outcomes, and lifespan correlate to race. It can also go the other way and demonstrate if race influences education level, lifespan, access to financial assets, all topics covered this year by the Federal Reserve Bank in their series, Racism and the Economy. Race is both an independent and dependent variable. Is this a divisive concept? Consider 354A33. No employee shall be subject to any adverse employment action, warning, or discipline of any kind for refusing to participate in any training that compels participants to express beliefs in the divisive concepts. If I view sexual harassment training as a divisive concept, can I refuse to participate? Can I refuse to participate in workplace safety training? And can I teach about work style differences between boomers, Gen X, Gen Y, Gen Z age groups? Consider 19340, the prohibition on teaching discrimination. This section states, nothing in this section shall be construed to prohibit discussing the historical existence of ideas identified in this section. How does an educator interpret their ability to discuss current events? Topics like prejudice leading to murder of black men, or violence against Asians, religious persecution of Uyghurs or Muslims, death rates from COVID-19, consensual sex, sexual exploitation of teens, or body shaming. Is talking about these topics prohibited because they involve discussing unequal treatment? Are we to teach to a world that doesn't exist, where everyone is treated equally, or to the one that does exist with all of its imperfections? Which of these approaches prepares me, our students, for the world in which they encounter that they're different from each other? Where do I see myself in the experience of others? If I read the testimony that we've received, vast amounts of testimony, we definitely need time to consider it. If I read that testimony of people supporting the current statutes, it's clear that they don't want critical race theory taught in schools. And if that's what this is all about, why did we need to cloak that fear in a statute that involves all other protected classes? And why didn't we take that issue head on? There's very little evidence that anyone in New Hampshire public schools teaches critical race theory. If there were objections to it, why not share that with school administrators and school boards? In the one incident pointed out in testimony, written testimony, that's what happened exactly. The consultant's contract was terminated. The point is, we don't need an ambiguous law that threatens teachers and public employees and drags New Hampshire through the press as a hyper-fearful state where bounties are placed on successful complaints against teachers leading to their dismissal. That won't fix our teacher shortage problems, nor any of our workforce shortages in this state. This is an example of hitting a nail with a sledgehammer. There are a lot of unintended consequences. There's a lot of ground to be gained by repealing the anti-discrimination divisive concept statutes and starting over with a dialogue about critical race theory, ways to address current issues of bias, and how to become more inclusive and accepting of differences. And that is the point behind this repeal and replace legislation. Let's take today to listen to the testimony of educators, students, human resource professionals, and parents, and use their testimony, in some cases very expert testimony, to address very real issues. This is the hearing we should have had last year. Thank you, Madam Chair. Be prepared to answer any questions.
Thank you very much for your testimony, Senator. Are there any questions? Senator Whitley, then Senator Gannon.
Thank you, Madam Chair, and thank you, Senator Khan, for your excellent presentation and challenging us to really think through what is a divisive concept, what is not a divisive concept. And I think you adequately described the ban concept statute passed last year as part of the budget as ambiguous. And I would agree with you. You know, I went to law school. I have my law degree. I have a bar license in New Hampshire and Massachusetts, practiced for over a decade. I also find it ambiguous. And furthermore, that that it is perhaps intentionally ambiguous. But despite the characterization of that ban concept statute as anti-discrimination in that statute, do you agree that the intent of that original language was to actually muzzle discussions about systemic racism, gender inequality, and other important aspects of our country under this guise of neutrality and equality? Do you think that was political doublespeak?
What I believe is that it has dramatically chilled the conversation in municipalities, other forms of government in the state, and in our schools. I think the confusing language is disrupting what people feel comfortable in being able to speak, teach, train in our public settings.
Thank you.
Senator Gannon?
Thank you. Thank you, Senator Khan. You brought up the paragraph that said nothing in this section shall be construed to prohibit discussing as part of a larger course of academic instruction this historical existence of ideas and subjects identified. So what I took out, to me, it was a very clear bill last year. I took and I read it 5 or 6 times in the last day. And it seems to me to say you can teach race theory, Black Lives Matter, you can teach any of these concepts. They're texting back and forth, oh my God, I won't use my child's name, but they have a different opinion. And it's if you feel different about any of these concepts, if you challenge part, if from affirmative action on, I've always felt I want equality, I want the best doctor. If I don't exactly agree with some of these principles and I'm in a public school, I am very ostracized as a student. So that's why we want, introduce any concept you want, talk about anything you want. But there are zealous teachers who tend to be more progressive in our public schools who advocate for principles. And that's where the line is. Teach anything you want, do not advocate for a principle. And that's what I read. And I know you don't see it that way.
I don't. I don't believe that teachers are instructing to a principle as you have described it. I think that teachers challenge students to think about events that have happened and to try to understand from different perspectives how those different perspectives view an event. And there's nothing more useful than using a current event as a teaching tool, because it's right in front of us. It's still, these things exist on a daily basis. So, and it's not just in the statute that fails to consider current events. It's also in the Attorney General's opinion that doesn't clarify current events. So I think the vagaries are quite apparent. And I think I'll let other people who are testifying today speak to it. But this chilling effect of saying that, of being silent on current events and using them as teachable moments about racism, sexism, and other kinds, I mean, that's part of the disturbing part of this, is that I think the offensive part is when people confront race. And this has been this broad sweeping that if you confront sexism, gender identity, handicap differences, that things that are quite apparent in our society, we start to obscure what maybe was the foundation to this statute, and it just makes unclear where the purpose here was and what we're actually trying to accomplish with this.
Quick follow-up, Madam Chair.
Yes, please.
Okay, very quickly. Just over and over again, I see that sections that are written in here saying nothing in this subdivision, all over the place, shall limit the academic freedom of the faculty, whether it be UNH in the higher systems to the K through 12. It all over the place says that you are allowed to have academic freedom. Again, the point is advocacy for a concept. And I think it's very clearly written and spelled out in last year's past legislation.
So one, I'll disagree on the uses of the word academic freedom. It's used only once, and in particular to exclude the colleges and universities from the statutes.
Final follow-up. It does say in other points, it says, so it does talk at the universities about that. It also goes into no government program shall teach. I think that was the K through 12 section. That's further, like a next page. So I saw it repetitively in the bill, but we can agree to disagree. Thank you.
Senator Whitley.
Thank you, Madam Chair, and thank you for taking another question. Just building off what Senator Gannon asked, do you believe that both the existence of the ban of discussion of certain topics plus the provisions that he's mentioning, do you believe that that is the crux of why this statute is ambiguous?
Yes.
Thank you.
Are there any further questions for Senator Khan? Okay, seeing none. Thank you very much, Senator.
Thank you, Madam Chair.
Next, we're going to call Senator Waters. And I would like to just say, if they can get Representative Ralph Boehm and Representative Deb Hobson that are out in the hallway, they'll be up next. Good afternoon, Senator.
Good afternoon, Madam Chair and members of the committee. And I almost feel I should say, Professor Carson, we're going to have quite a seminar today, aren't we?
You know, it's a learning experience.
Yes, well, I hope so.
Every day is a learning experience.
I really hope so. I'm Senator David Waters, District 4, and I want to talk in support of Senate Bill 304. And I'm going to try to be fairly brief today and just talk particularly about the meaning of that word inherently. because I think the word inherently has proved to be the problematic one here. And in part because the Attorney General has interpreted the word inherently as something that also belongs by settled habit. And I think that's where we get into difficulties, and I think, Senator Gannon, that this notion of settled habit is where we are in a problem area in terms of your interpretation of the language of the bill. Now, settled habit, and you look at, the definitions here and why the Attorney General came up with this as a part of definition of inherent. And, if we look to the definition of inherent, we get involved in the constitution or essential character of something, belonging by habit or nature. So then we think about, well, then what is habit? Usual way of behaving, something a person does often in a regular and repeated way, the settled tendency and usual manner of behavior. Now, I would submit that this is what societies do, that they create settled matters of behavior and ways of doing things, and that's what creates our history and the values that a society has. And certainly we know that there have been settled habits about issues of equality in this country, despite constitutional amendment laws and Supreme Court decisions, that settled habits have proven very potent, and I think in some ways why we have a continuous struggle over the meaning of the word freedom. And I will say, too, that this is what cultures do. Take a look at the definition of culture. It's the beliefs, customs, arts of a particular society, group, place, or time, or a way of thinking, behaving, or working that exists in a place or organization. Socially instilled habits. That's what a culture is, and I think that the Attorney General's interpretation here means that teaching settled conditions or habits or systems of law or patterns of behavior might run into trouble as far as this goes. Now, let me talk about that word inherently, and because I think if we look back in the history here, we'll see that this is a word that has troubled Americans since the founding when it comes to these issues of equality. You probably, these words may sound familiar to you. I want to read a phrase from the draft version of the Declaration of Independence. And Jefferson, with all men are created equal, that they are endowed by their Creator with certain unalienable rights. Now, what happened to that word inherent and inherently? Why did it become a problem? It's interesting to note that John Adams, before the Declaration of Independence, had helped to write the Massachusetts Constitution, which used that word inherent. And that's why we have it in our Article 1, where it says all men have certain natural, essential, and inherent rights. Well, why did Jefferson feel that inherent had to go? And I think we can find out about that if we look to his 1784 notes on the state of Virginia. And he really here tries very hard to parse out what does inherent mean. Is it really something that we would think of genetic now or essential to the constitution of individuals or a group of people, or is it something that is created by habit, by settled habit, by cultural practices over a long time? And then most importantly, he kind of tries to figure out, philosopher that he was, that can we determine inherent characteristics from patterns of behavior and culture? Now, what's at stake for Jefferson here? And he wrote this in response to legislation, which he had originally supported to end slavery in Virginia, because he realized that if he was going to hold to that idea of equality under the law, that he had to find a way of distinguishing African Americans from the category of men, so that they aren't covered by the notion of inherent unalienable rights. And let me just read you the kind of key sections from that, where just interested to watch him wrestling with this, and I think it's still the same struggle we're having today. He says, the first difference which strikes us is that of color. The difference is fixed in nature and is as real as if its seat and cause were better known to us. And is this difference of no importance? So here's where he gets at it. Can we observe by characteristics, whether it's color or behavior, that there is an inherent difference? And he says, is not the foundation of a greater or less share of beauty in the two races? And to these flowing hair, a more elegant symmetry of form for Caucasian folks, their own judgment of African Americans in favor of the whites declared by their preference of them as uniformly as the preference of the orangutan for the black women of those of his own species. So you see the comparisons being made there. He said the circumstance of superior beauty is thought worthy of attention, the propagation of our horses, dogs, and other domestic animals, and why not that of man? This is besides those of color then, and here's what I'm trying to get, what does this reveal about whether somebody has essential humanity? Besides those of color, figure, and hair, there are other physical distinctions proving a difference of race. Comparing them by faculties of memory, reason, and imagination, it appears to me that in memory they're equal to the whites, in reason much inferior, than imagination they are dull, tasteless, and anomalous. And he concludes, I advance it therefore as a suspicion only that the blacks, whether originally a distinct race or made distinct by time and circumstances, are inferior to the whites in the endowment of both body and mind. So you see where he's come there on that inherent. It says if we can't truly know exactly what the biological thing here is, we can understand that over time and by culture, that those things evidence an inferiority. Now this became the received wisdom and the basis of law for, well, really almost 2 centuries in our country. And would lead him to say that the category of man does not include people of African descent because of this dispute over inherent behavior. Now, so what? Okay, now that you see inherent here, why is that a problem? Now, I think that understanding Jefferson's struggling over this, it enriches our notions of what freedom meant then and means now. I think it enriches our notion of the struggles then. Jefferson had this struggle, trying to figure out what inherent meant and how we should act upon it, how we should legislate on it. And it's a very human struggle. It's a very human struggle for freedom. Robert Frost once said that the words of Jefferson in the Declaration will trouble this republic for as long as it stands. And guess what? Here we are, troubled by it again today. And as I say, laws, the Constitution have changed. Supreme Court decisions, Plessy versus Ferguson, Brown versus Board of Education, but those settled habits about race and other categories are very, very hard to change. And so what we're saying to teachers is that if you talk about this as a settled habit or a pattern in American law or American social practice or in American education, that you have tripped the wire, in the Attorney General's opinion, as to what that word inherently means. Now, I think we're going to hear a lot, and I'll finish up with this. We're going to hear a lot about the impacts of this, the chilling effects. I was at a meeting of our advisory council on career and technical education. There's a little discussion about hiring issues, and I heard that applications, not just for CTE, but for 4th grade teachers, had fallen off a cliff. And they said that what they're hearing is that teachers, we used to be a magnet for teachers around the region. This is a great place to work, to live, we all know that. But the teachers are saying, why should I go to New Hampshire, where I might be liable, not be able to teach, what I think is what we should teach, and also might be liable for legal action. And so this is what we're hearing. I think this is a practical effect. I think that, that people wanted to read that word inherently as being innocent or meaning one thing, when after the Attorney General's opinion, it really seems to me to obviate Senator Gannon that language that seems to say you can teach the history of this or that, because it's not a question of advocacy. It's just saying, was this a settled habit in our country? Is this a history here as Jefferson recognized it and justified it in his own language? So that's why I think we really have a problem with this statute. Thank you, Madam Chair.
Thank you very much, Senator. Are there any questions for Senator Waters? Yes, Senator Whitley.
Thank you, Madam Chair, and thank you, Senator, for, as always, digging deep into our history and giving us such a clear picture of why we need to move forward in a different way. So I appreciate that. And I am curious, in your experience as a legislator, are you aware, can you think of any other example where this legislature, where the New Hampshire legislature has actually banned certain topics of conversation, have said to our teachers, you can say this, you can't say this, you can discuss this, you can't discuss this, rather than allowing debate on the actual merits of an issue. Are you aware of any other time this has happened?
Well, thanks for your question, Senator. And it's kind of interesting, and I don't know if Senator Carson remembers back these days too, but when I first started teaching at the University of New Hampshire in 1978, I was presented with a document that I was supposed to sign before I could get a contract that said that I was never a member of Communist Party or any group that would advocate the overthrow of the United States Constitution, and told that if I didn't sign it, I wouldn't get a contract. Now, I didn't sign it, and the irony is we never have had, in my 40 years at UNH, we never had contracts. But regardless, the history at UNH had been in the 1950s attempts to have state police sitting in classrooms of professors. There's a famous legal case that derived from concerned about our children. We love them, we want with this, and we've come up with this kind of opt-out system, right? Mm-hmm. But here what we're saying is that nobody can opt in. You can't even opt in, let alone the issue of opting out. So those are, I think there are other examples as well, but those are two that come to mind.
Thank you, Senator.
Are there any further questions for Senator Waters? Seeing none, thank you very much.
Thank you so much.
After Representative Bohm and Representative Hobson, we're going to call Representative Nodder and Representative Perez. Representative Bohm, Representative Hobson.
Thank you, Madam Chair. My name is Maria Perez. I'm a state representative for District 23 in Milford. It is my honor to support this bill. As an immigrant and someone who's been here 35 years, back in the day, I worked with a company that I helped doing human resource management and administration. I was handling between 150 to 300 people a week. These people that came from different cultures, different backgrounds, and one of the things that I really appreciate from that background is learning different cultures, different backgrounds, learning what makes people happy in other cultures, and what we see, like, maybe it is not something that we so used to, but to be honest, learning everything about these cultures, learning about everything about people's background, it helps us to make them feel welcome. And I believe New Hampshire, since I've been here 35 years, I feel New Hampshire before they used to feel like it was a welcoming state. Right now, I feel like a lot of people, they feel like they have the right to not to have a filtration, and they treat you like the way they feel. They feel like they have the right to tell you that you don't belong here because either you look different or because you have an accent, like myself, I have an accent, but I do have tongue-tie as well. I have a medical condition that sometimes the words don't come out right, and they don't sound like, I speak English correctly. But, I believe this bill, it will help us to continue that benefit from companies, especially companies like I used to work before, that we used to send people. I even went to Costa Rica. We used to train people from Mexicali, Costa Rica, and it's good to have companies that can teach, about cultural backgrounds and different views, because it is good when we go to different countries to realize that they have different beliefs, and then learning about those beliefs and learning how to respect those things, I think it will make, a better work and then make New Hampshire more welcoming. And that's what I have to say. Thank you so much for your time.
Thank you very much for your testimony, Representative. Are there any questions from the committee? Senator Gannon.
Is there something, I think I agreed with everything you said, but is there something specific in last year's legislation? Again, I see it as I can teach anything about anything that ever happened in history, anything that happened in the culture. I just can't advocate, which I see over and like a systemic racist, that because you're white, you can't understand someone else's position or that you have inherent bias. That's what I don't want taught. I certainly want everything about every culture to be taught. I'm fairly friendly with Jeb Bush and his wife. She's Mexican origin. I know a lot about the culture there. I have nephews and nieces from Korea. Education's the most important thing to me, and if I really thought that this was limiting the ability to teach, I wouldn't be advocating for last year's bill. But I don't see the limitations.
And to be honest, with all my respect to you and everyone is here, we already see systematic racism. We already see people treating people differently because the way we look, the way we act, and this bill, the language that we pass on that bill, it gives people the ability to feel like that they have more rights to treat everyone. And then I see parents in social media saying, if the teacher's teaching my kids something that I don't feel comfortable, I'm going to sue that teacher. I'm going to make sure that teacher lose the licenses. And that's something that I don't want to see. We already have enough hard time keeping up with the teachers. We already have enough hard time, with the kids feel like they can be part of one group. I don't see anyone black, white, or Latino, or whatever. I see everyone as a human being. And I think, when we bring this kind of language and we bring these divisive ways to put, this kind of language in the school system, it's not helping us. It's not helping us. It's teaching the kids that they're different because they're white or they're black. And I don't see that the language on the bill from last year that was going to help us to make the things that we've been working so hard to make everyone feel welcome, to feel everyone that's like they have the same rights and they're still humans. They're still human. I don't care how you look like, or I don't care how you speak. Even with disability, we have a lot of immigrants, disabled, that we have to make sure that the teachers understand. We have to make sure that the teachers can allow to speak some of the things, especially when, a lot of taboos in our culture, like especially in my culture, Latino culture, mental health and other things that, domestic violence. Those are the things that we don't allow us to speak. And I think it's good to allow the teachers to talk about things that, that sometimes they're not easy, but they has to be talked because otherwise we cannot understand what exactly is happening, especially in the minority groups.
Thank you, Representative.
Excuse me. Senator Khan?
Thank you, Madam Chair. Representative, do you think that the use of the word prohibition on public employers and prohibition on educators on teaching discrimination, do you think that the word prohibition is part of the reason why we're here and confused about whether this is enabling or prohibiting?
I believe, that what we're doing with this bill, and I believe supporting this bill, is what we need because we don't want to disable the teachers. We don't want to disable the companies to be able to teach what we need them to teach. We can't just tell the teachers, you can't teach this, or because you're going to get in trouble. How much they can teach without getting in trouble. We have to make sure that the teachers feel comfortable. We have to make sure the employers feel comfortable about bringing those issues that, like I say, in a lot of cultures like mine, they're taboos, and then we have to utilize and make sure that they have the right to be speaking about those issues.
Thank you.
You're welcome.
Are there any further questions for the representative? Seeing none, thank you very much for your testimony, Representative.
Thank you.
Next, we're going to call Margaret Burns, and after Margaret Burns, I think it's Andrea Chatfield. I think I got that right. Okay. Good afternoon again, Ms. Burns.
Good afternoon. Margaret Burns with the New Hampshire Municipal Association. We are here this afternoon in support of Senate Bill 304, which would repeal language that was added to the state's human rights statute last year. Last year, we opposed House Bill 544, the bill that gave rise to this language, and we also opposed the language that was included in House Bill 2. Although we do not specifically have a position on whether or not municipalities should or should not teach the topics enumerated in this new law, we oppose the state controlling and dictating what municipalities, in their capacity as municipal elected officials or in their capacity as municipal employers, are allowed to discuss, teach, train on, or talk about with their employees.
Prior to the passage of this law, we had not heard about issues, complaints, or even efforts to train or teach about critical race theory or other topics related to critical race theory that have come up in the discussion of this legislation. However, after the passage of the law, we heard a lot of angst and confusion from our municipal officials about what they were allowed to talk about and not allowed to talk about. This was particularly true in communities that had started very recently with some of their efforts around equity and diversity training, creating committees and councils, and putting on trainings and hosting other listening sessions, either for the community, for their municipal employees, or both. We have heard from many municipal officials that they are concerned that they do not know what they are allowed to do and not do, and whether they are allowed to proceed with plans that they have or efforts that they have undertaken based on this law. In fact, when the law was first passed, many stopped their efforts waiting for the Attorney General's office to issue the guidance that it did inevitably issue to try to help them understand what they were allowed and what they were allowed to train on. What we have ultimately seen is that this has created a chilling effect, and that municipal officials are afraid to move forward with various trainings and other efforts for their municipal employees. Because public officials and employees are capable of deciding for themselves what to teach on, what to talk about, and what the discourse should be around these topics, we believe that Senate Bill 304 takes a much more prudent approach by embodying the fundamental principle of free speech by stating that a public employer is not prohibited from engaging in or requiring various training on topics enumerated in the statute. For these reasons, we encourage the committee to support Senate Bill 304 and the repeal of last year's legislation. Thank you.
Thank you very much, Ms. Burns. Are there any questions from the committee? Senator Gannon.
Thank you, Attorney Burns. In last year's legislation, again, and Senator Khan pointed out, I've talked about it, doesn't this do what you want, where it says nothing in the section shall be construed to prohibit the discussion as a part of a larger course of an academic construction, the historical existence of ideas or subjects? Isn't that fairly clear that you can teach concepts?
That section, if it stood alone, as the legislation that was passed, would be very clear. But it seems to contradict and butt up against the other enumerated topics that municipal employers are prohibited from training on, teaching about, etc. And so that internal conflict within the statute, as well as some of the terms that have been brought up in prior testimony, the definition of inherently, and some of that other ambiguity has really led to this halting on the municipal level from undertaking some of the efforts that they planned to undertake.
Quick follow-up.
Follow-up?
In Senator Khan's new bill, where he talks about current experiences or engaging, you're familiar as an attorney with probably more than I am, with overly broad. Isn't this hard, his just as hard to pin down as the last version? When I read his bill, I see a broad vague for broadness would be a court's thing to throw it out. Isn't that same inherent conflict in the new bill?
I think that no, I don't think it creates the same conflict, because what it does is, rather than banning speech and putting us in a position of determining what is and is not allowed, Senate Bill 304 opens up a channel for the ability to talk. And so having the openness that is created through Senate Bill 304 and not prohibiting specific speech, I don't think creates the same ambiguity that we're seeing in the law that was passed last year.
Thank you.
Thank you.
Are there any further questions from Ms. Burns? Okay. Seeing none, thank you very much.
Thank you.
Next, we are going to go to Andrea Chatfield, and after that, we're going to call Megan Tuttle.
Good afternoon. My name is Andrea Chatfield, and I am here representing the HR State Council of New Hampshire. I serve as the Legislative and Government Affairs Chair of the State Council, and I'm here on behalf of the over 1,000 members of HR professionals that the State Council represents and serves. For those unfamiliar with the HR State Council, it's a membership organization that's affiliated with the National Human Resource Society of Management, usually called SHRM. And our members, our HR professionals, represent the front lines in workplace law compliance. So when you talk about the legislation that was passed last year, it's our folks that have to figure out how to do it. And that's why I'm here today, to speak about it. We had concerns about it last session, and we submitted objections to that, to the Divisive Concepts Law, and we continue to have objections and concerns. The HR people or HR professionals are the ones that are typically responsible for ensuring that their workplace complies with the anti-discrimination laws of RSA 354A and all the federal counterparts. And one key way of doing that is providing effective training on diversity, anti-harassment, anti-discrimination, inclusion, and equality, and equity. But the legislation that was passed last year, especially in connection with RSA 354, sections 29 to 34, really hampered their ability to figure out how to do that. And I'm going to mention three key areas or three key concerns we have. The first is that the law leaves employers vulnerable to employment lawsuits or discrimination lawsuits. How does it do that? Illegal discrimination is not always an overt act, and it's not always intentional. So how do you train people to understand that and to understand that their actions hurt people and can hurt people? The EEOC and courts have long recognized that unlawful discrimination can stem from stereotyping and unconscious bias. Patterns of lower pay from females in an organization, a pattern of older workers not being able to find new employment, or situations where qualified people of color or people with disabilities not being promoted or given employment opportunities are patterns that can lead to discrimination lawsuits. And it's those patterns that you need to, a lot of times, address in the workplace trainings. Employers have to be vigilant. And how can an employer, if an employer cannot train or counsel its managers and supervisors on how to recognize those types of patterns, leave themselves vulnerable to being sued? In no way should the state, in shutting down discussions, in chilling trainings, should in any way make employers vulnerable to these types of lawsuits. I'll give you another example. I had a client who had a difficult manager. He was being very dismissive to his female subordinates, to the people of color that he supervised. And he really benefited from having some one-on-one sensitivity training, diversity training, and management training. Under the current legislation, or the legislation that was passed last year, he could have refused to participate in that. To say, nope, you're making me do that because you're saying I'm inherently racist or I'm inherently sexist. And what would the employer have to be able to do? That's where this law really hurts the ability of the employer to effectively manage its workplace, to make sure that they're not engaging in discrimination, harassment. Another reason or concern we have is how this legislation, or the legislation that was passed last year, would hamper effective diversity and inclusion training. You've heard from prior speakers. I won't try to repeat what they said, but from the perspective of HR professionals, these are conversations that can be difficult but important to have. In understanding how race or gender or even age and disability and sexual orientation and the stereotypes built around those protected statuses, how it can influence our decisions and our actions towards others, are difficult but important conversations to have to achieve diversity, equity, and inclusion. But this makes it very difficult for me, an employment law attorney with 30 years experience in devising and in designing anti-discrimination and anti-harassment trainings. It makes it difficult for me to figure out how to do that while navigating the issues here, while not causing people to assume I'm saying they're inherently racist or inherently something. And let's face it, there's a lot of good arguments to be made that people do have inherent bias, unconscious bias, in a lot of different ways. I know we've talked a lot about the race issue here, but the statute that was passed last year It involves all the protected legal statuses. So how do you have a discussion to help perhaps employees of a younger generation understand that the way that they're treating could be discriminatory against older generation? Because they don't have the perspective of the older generation. They don't have the empathy. And think about how able-bodied employees might be treating disabled employees and the inherent stereotypes that they may be acting upon. I need to be able to train people to understand that. And statute doesn't do it, doesn't let me do that. Another concern we have is that the remedies in the statute that was passed last year are very interesting to me. In section 34, it says an employee who feels they've been violated by the statute can pursue all remedies, not only under 354A, but under 275E, in a court of law, under tort, under all these other statutes. That's extraordinary to me, that a violation of the training part, of the prohibition on trainings part of the statute, can lead to far more remedies than a violation of the main body of 354A to begin with. And even though they only have remedies for one or the other, they can certainly sue in all those forms. And then I'm trying to defend a lawsuit in all different forms. That raises the concern that there is an intention that really the legislation passed last year was to chill DEI trainings. That is the impression that gives. Finally, a lot of the prohibitions in RSA through 54A, 29 through 34, prohibit things that really are unnecessary to prohibit. To say that I can't tell somebody that they cannot discriminate against somebody or that one race or one gender is superior to another, any professional worth their salt will tell you, we would never say that in a training. We would never teach that in a training. It goes against the statute. Or that anyone should be discriminated against because of their race or their gender or their nationality. We would never have that in a training. HR people get that. So the prohibitions are unnecessary even of themselves. For these reasons, the HR State Council supports Senate Bill 304 and its repeal of RSA 354A, sections 29 to 34. Thank you for letting me have the opportunity to speak to you today.
Thank you very much for your testimony. Are there any questions for, okay, we have Senator Whitley and then we have Senator Khan.
Thank you, Madam Chair, and thank you for taking my question. I appreciate your, as an expert in employment law, I do appreciate your analysis of the statute because I think there has been a lot of conversation about the ambiguity of the statute. So I appreciate your analysis. So as an expert in employment law, do you think that, or do you believe that the banned concept statute that passed last year has the potential to drive away businesses, hamper recruiting for a qualified workforce in New Hampshire? Do you have those concerns?
First of all, I have to correct you. I'm not an expert in anything. As a practicing attorney, I cannot hold myself out as an expert. I can only say I have 30 years I've been practicing employment law.
I can call you an expert.
Thank you. But would it drive away business? Well, first of all, the statute as written last year applies only to public employers. So from a private employment standpoint, from a business standpoint, I don't think it would have any effect. But I worry about the disparity that's going to develop between people who are employed in the public employment sector and people who are employed in the private employer sector, who will have the benefit of meaningful and robust DEI training. And I am worried about the disparate impact that will cause in the functioning of our public employers in under 354A versus private employment.
Thank you, that's helpful.
Senator Khan?
Thank you, Madam Chair. Ms. Chatfield, I have found you to be one of the brightest voices on employment training in the state, whether that be on unemployment compensation or health care plans and changes in health care laws. You are terrific. So I appreciate you taking time today to come to this committee. And I'm wondering, given 354 has been on the books for quite some time, and no doubt you have done some anti-bias and anti-discrimination training in the past. Do you think these statutes are necessary, that the kind of shaping of our discussions that these statutes have had in the past without what we adopted last year? Do you think that that already existed in 354 without this additional language?
Absolutely. 354A itself is a robust statute. It covers many protected statuses, many of which are protected because they're so vulnerable to stereotypical thinking. And I think RSA 354A has been a very strong statute, and I will say that I think the New Hampshire Human Rights Commission has done an admirable job in defending and enforcing the statute, and I think that they've been woefully underfunded. But certainly, anti-discrimination laws, it's one of the reasons I love doing employment law, because it's about treating people fairly and focusing on what's important, how they can do their job. These types of the statutes are really necessary today, and they're still necessary. And even if it wasn't for overt acts of discrimination, it is the subtle forms of discrimination that I really feel we see a lot of, and we need to keep training employees about proper workplace behaviors in those areas.
Thank you, and thank you for taking time.
Are there any further questions from the committee? Okay, seeing none, thank you very much. Next, we're going to call Megan Tuttle, and after that, Jake Berry.
Just want to check the red means it's on right. Okay, I haven't done the testimony here before. Hello, thank you for having me today. My name is Megan Tuttle. I represent more than 17,000 New Hampshire educators. I'm the president for NEA New Hampshire. For more than 168 years, it's been our mission to advocate for the children and the educators of New Hampshire and the public school employees. We're committed to improving student achievement in New Hampshire public schools, providing learning opportunities for teachers and students, and ensuring that all students are ready to succeed. NEA New Hampshire has held from the beginning. Is it easier to hear? Okay, I apologize, sorry about that. I'm further enough away. Oh, sorry, it's just stuck. Is that good? Is that, okay, so. So NEA New Hampshire has held from the beginning that the current law's vagueness would have a chilling effect on educators throughout the state. After seeing the law in action this year, our members, our students, and their parents know that this is true. After this law was passed, NEA New Hampshire made multiple requests for specific guidance and instruction to assist educators in staying with the new law. These requests were sent to both the Department of Education and the Attorney General's office. To this date, the requests have gone unanswered. New Hampshire is consistently ranked in the top 3 or 4 states in regards to public education. Our students in our state lose if opportunities to constructively address race in our classrooms are muzzled and criminalized by this law that's vague on content and unyielding in punishment. AP English teachers in our state are now worried about continuing to use the Pulitzer Prize-winning book Beloved in their high school AP English class, as the book centers on the traumatic legacy of slavery on the characters. They no longer are asking their class whether slavery had a legacy elsewhere in American culture, government, or policy, and allow them to discuss, explore, and defend their opinions, because they fear the discussion will be misinterpreted as indoctrinating students in violation of one of the prohibited areas of the Act. Many educators now worry that the Banned Concept Act impedes competency-based teaching. They feel as though they cannot allow students to dialogue with each other, to peer review each other's work, or to let students lead classroom discussion, because they don't know if student-driven learning will lead to a discussion that could be interpreted as the instruction of a banned concept. The law's broad use of the word teach dissuades teachers from presenting material as a jumping-off point for discussion, because they could be accused again of indoctrinating students simply because they expose them to one author's thesis. Our teachers feel that they must now teach material in a vacuum in order to limit the analogies students may draw to current events that could address one or more of the banned concepts. They're hesitant to ask questions like, does what we just read or saw apply in your life? Where do you see this happening now? because they're concerned open discussions like that might veer into banned concepts. Teachers believe that students are disadvantaged by the law because they're not being given the opportunity to form their own opinions or perspectives on important social and historical issues. For example, they're not being given the opportunity to read stamped from the beginning. The students cannot determine if they agree, disagree, or have an alternative opinion to the author. They're not developing analytical skills to support any opinion they could form if they're not permitted to engage in discussion with peers or teachers about the author's failings, misunderstandings, or flawed reasoning. While ignoring our request for clarity on the new law, the Department of Education installed public mechanisms for reporting teacher-educator noncompliance and procedures to take away teaching credentials, prompting what we believe is the first bounty ever offered on an educator. Teachers believe that the false reports of violations of the Act would be extremely damaging, as they would cause unnecessary controversy and attention up to and including reports to the Department of Education, disciplinary referrals, and investigation by the school district, not to mention harassment and unwanted attention via social media and news coverage. To that end, educators are either declining to use permissible works altogether or removing controversial authors' names from the materials prior to presenting them to students. The chilling effect of the Banned Concept Act is New Hampshire educators are now weighing meeting minimum state standards against losing their license and their livelihoods. Parents and teachers want to provide the best they want to provide the best education they can to our children. But the Banned Concept Act has created an environment that limits the context in which kids can learn about history and what books they can read. We need to trust educators and parents, not politicians, to ensure our kids get the best education possible. Teachers are trained and experienced in education. They have a duty to set their students up to be successful contributors to society. Educators should have the freedom to teach the honest, complete facts about historical events like slavery and civil rights without being censored by politicians and having their licenses and livelihoods put at risk by a vague law. Senate Bill 304 restores the ability to provide diverse educational approaches to instruction and curriculum tailored to meet students' needs. Our students deserve the freedom to learn. They deserve to be part of an education that helps them learn from mistakes of the past. They're better prepared for the future to succeed. And to inhibit New Hampshire's educators from engaging in the kinds of discussions that help teach and challenge students to use this knowledge to form their own opinions is a disservice to them, the state of New Hampshire, and our country. On behalf of NEA New Hampshire and its membership, I respectfully ask that you find Senate Bill 304 ought to pass. I do want to add that I was a social studies teacher for 18 years as well. A social studies teacher, I taught 8th grade U.S. history, so this is something that is near and dear to me as well, and I do have 3 children in public schools in New Hampshire, so coming at this from, the president of NEA New Hampshire, representing the educators, I'm also a parent, which helps, so thank you.
I'm going to go first, then I'll take it.
Sure.
Couple of questions. First statement, so I have 4 kids, 3 have made it from K through 12 public into little Ivies or Ivies. So I love education, my most important thing, and I don't want to hamstring you at all from teaching. So a lot of people are fearful that if they bring up any challenge, or like you said, the teachers are fearful, the students are fearful if they ever take on any issue, if they question one segment of an LGBTQ issue, they question one little part, they might not be 90% there on Black Lives Matter, if they bring up anything, they are stigmatized as racist in these schools. First from the NEA, I've got so much paperwork today, and I got something, and it just bothered me a little because it made me think the NEA is slightly biased, because it said that the NEA at their last meeting on anti-discrimination protection in public schools, as far as teaching discriminatory ideology, it said that they passed a resolution saying that they were to teach in schools CRT and the 1619 project. And that was approved at the annual meeting. Do you know if that's true?
So that's the national that you're talking about, not NEA New Hampshire. And the national, when we meet in the summer for the Representative Assembly, I would have to honestly go back and look at that. There was about, I think, 150 NBIs that were brought up this summer, so I don't exactly remember them all. If it was passed, it would have been passed by the majority, but that doesn't mean that NEA New Hampshire was in support of that.
So I have had great teachers, social studies, in fact, Mr. Kelly in Timberlake. And my kids were the only Republicans in the class, or at least the only ones who, so every issue they've always been, if they had a question on anything, they have been challenged and somewhat ostracized because they have slightly more right-leaning thoughts. As far as anything from global warming to, if they have, not that they don't agree with the concept, but they might have some disagreement. And so if they have any challenges, the problem I know a lot of parents is fearing, and that's why the language is put in, that you can teach the systemic racism. We understand, and I know we all look at things through a different colored lens. I was taught this millions of years ago when I was in school. And I understand that, but to teach them that because of, as Senator Khan, I thought inherently was an easy term, I guess it isn't. To me, it's an immutable characteristic to present to people that you're really nothing you can do. I have friends, I grew up in a very liberal environment in Concord, Mass, and they told me, you're white, you're inherently, you can't see around the racism. And that bothers me to hear that, and I don't want my kids to be told that they're inherently racist. I want them to hear the concept and to know what's going on, but then they're going to be bullied in a lot of public schools, and if they don't accept every aspect of something. And that's where our fear is, and that's what we were trying to protect. This was a watered-down bill. This wasn't the House's bill, which is a much harsher version. This was somewhat of a compromise to try to bring two parties together, and I'm afraid that Senator Khan's bill is what it's doing is dividing the state into a very progressive group versus a very conservative group. I want to find a middle road where we can all work together. And so to totally throw out the old bill and not say there's anything good in there, it seems to be a one-sided thing. We're in a world where everything's very polarized, and if you can't seem to find a middle road. And that's what we were really trying to do with this, was find a middle of the road. Do you see any middle ground between Senator Khan's bill and last year's bill that we could work with?
Respectfully, no. And I'm listening to everything you're saying and hearing you, but I think, part of the issue that we have with the bill that was passed and signed into law last year is the word teach and the fuzzy line between teach and discussion. And so, I'm hearing from educators all across the state, from teachers, and we talk a lot about just teaching in this, right? We talk about the teachers that are doing this, but ultimately the bill that's currently in law really applies to anybody in the school system. It applies to anybody that works in the public schools. Yep. And so it's not just the teachers, it's any educator. And that's why, I use educator as opposed to just teacher, because it could be somebody in advisory where a discussion comes up, et cetera. And so there is that kind of more far-reaching piece of it than just what could happen in, what's typically thought of in just a history classroom or an English classroom. This could be anywhere in the school. But it's a fuzzy line between teach and discussion. And what I'm hearing directly from the educators in New Hampshire, from Hillsborough County, from Cheshire County, I have specifics, and I will forward. I apologize that I found an error in what we typed up, and I didn't want to pass it in today. So I will have it emailed to everybody tonight on the committee, so I apologize for that. And I have specifics in the email. I didn't want to take up the complete time telling the stories of the teachers, but that's what it is. Anyway, getting back to it, what I'm hearing from the educators and the teachers in the different parts of the state is they're afraid to even bring up anything, because they don't, the fear they have is they can't just teach. They're afraid that if something is misinterpreted, or it's brought up in a way that doesn't agree with what they might be saying, that their name's going to be put into the website that's put up by the DOE. Someone's going to get $500 because that was out there. That's not a secret, and they don't want to do that. There's a fear that they can't just teach. And I taught, 8th grade social studies for 18 years, something I told my students every single year: we have to learn from the past so we don't repeat it.
So I think when we wrote the bill, we wanted you to be able to teach, we wanted you to be able to discuss. And again, I'll go back to the same word, just not advocate that this is really the good way and the way to see it. Okay. Anyways, thank you. Senator Whitley had a question. Thank you for taking my question.
Senator Whitley.
Thank you, Madam Chair, and thank you for your testimony. I personally think that, particularly in the past 2 years, the teachers are heroes. I have an 8-year-old. We started the pandemic, he was in kindergarten, he's now in 2nd grade, and what teachers have been able to do to support students in every single way has been incredible. And so I'm deeply grateful to our New Hampshire teachers. They are the backbone of our state, and they are preparing the future of our state, and they're just incredibly important. So I want to just build on, again, what Senator Gann was saying. Do you think that banning concepts of discussion actually solves the problem that he's identifying of stigmatizing and bullying? Or would you agree that debating the issue and working with students, helping students through difficult conversations in a respectful way is a better way to prepare our students for the future and to compete in a modern world and to be participants in our modern workforce?
Yeah, I do think that's a much better way to do it. I think banning it puts it more in the forefront of, this is something we shouldn't be doing. But at the same time, we don't even know what exactly is banned because the law is very vague. And we have asked, I'm going to forward the letters to you, we've asked for specific things that are banned. We wanted specifics. We wanted to be able, when this law was passed, we wanted to be able to go back to our, our 17,000 members and say, okay, this is the clarity that we have from the Attorney General's office and from the DOE, and we still don't have that clarity. The law is just too vague, and there's too many questions in it. And when you're looking at, your livelihood being put at risk, if your name gets put into that email and you get an investigation through the Human Rights Commission, even if it's found to be nothing, that's still your reputation as an educator, and that's still your reputation as a person, and that's really hard to come back from. And I think there's a definite positive to be able to discuss and debate, and being able to teach children how to do that in a positive way instead of just I'm right and you're wrong. That's something that we have to be able to do, but there's a lot of fear around the state right now that we can't even discuss or debate because they don't know what's going to come out of that. And so teachers are afraid to even put the questions out there to do that because of the law.
Thank you. Follow up?
Yes, follow up.
Thank you, Madam Chair. Thank you for that. I appreciate that as, your perspective, also as a social studies teacher, that importance of debate. You mentioned how, this chilling impact, we have heard about a lot of that. We're going to hear more of the chilling impact. Regardless of how a lawyer reads the statute, it has had a chilling effect. And we know teachers are scared. And so I'm wondering if you heard from any teachers where they were even scared to come testify today.
The teachers in general, speaking out is tough for a lot of teachers just because they want to do what's right by the kids. And so they have, it's tough. Part of that is the timing. And I hate to say this, but it's the logistics. Part of it is the timing and getting teachers to come out. They're not going to leave school to come here because if they leave school to come here, they're going to get, criticized for that, for standing up for something that they believe in. And so it puts them in a really difficult position in a catch-22, which is why I'm thankful that I can be here to speak for them. I have stories from them. I have, curriculum that was written with the cooperation of administration on books and lessons that were written prior to law being passed, and now those books are being shelved. And so money was spent. They're sitting collecting dust on the shelf. They're just not teaching what they had been teaching. So all the lessons are being rewritten. They're being redone because of this. And that's a fact. This is what the teachers are telling me from Hillsborough County, from Cheshire County. It's the 8th grade I'm hearing from when they're working the social studies teachers with the English teachers together to teach units, interdisciplinary. Those are being put on hold and things are being rewritten. AP English class where you can get college credit. I mean, all those things are happening. These are from the teachers in New Hampshire. And yeah, they're afraid. They're afraid that if they, come testify, something could happen. They're afraid of that.
Thank you. Thank you for your testimony.
Thank you.
Yes, Senator French.
Madam Chair, could you get this committee a list of the books that have been shelved?
Yeah, I can try. The two that I've heard about are Beloved and Stamped from the Beginning, the children's version of it. Those are the two that I keep hearing about. But I can definitely put out something and ask if there's other ones.
Great, thank you.
You're welcome.
Are there any further questions? Senator Whitley, then
Yeah.
Senator Khan.
Thank you, Madam Chair. I appreciate that opportunity. Would you be surprised if even in my own community, I've heard Hopkinton School District has started to, pull actual books from their curriculum? Would you be surprised?
No, not at all. And I know that there's other areas of the state that they're looking at the libraries and looking to pull books from the libraries and schools as well.
Thank you, Madam Chair. Thank you for your testimony today, and I think any specifics that you can offer to the committee will be helpful. Along that line, if the inquiries that you have directed to the Department of Education that have not received a response in a reasonable time frame, If you could share those questions with the committee, I think that would be helpful too.
Sure, thank you, Senator. Yeah, I do have those as part of what I intended to turn in until I found the error, so those will be forwarded to the two requests that we did send to the Attorney General's office and the one we sent to the Department of Education and the Attorney General's office. I will have copies for those, of those for you this afternoon.
Thank you.
You're welcome.
Thank you very much for your testimony this afternoon.
Thank you.
The chair will call Jake Berry and then Devin Chaffee after that.
Okay. Madam Chair, honorable members of the committee, my name is Jake Berry. I'm the Vice President of Policy at New Futures. As many of you know, New Futures is a nonpartisan, nonprofit health policy and advocacy organization. We work to improve the health and wellness of all Granite State residents. And as New Hampshire's authorized Kids Count organization, we advocate for database policies that support all New Hampshire families. I'm not here just on behalf of New Futures, but on behalf of many of our advocates and partners who don't feel that they can safely attend these hearings in person and make their voices heard. I don't want to repeat too much of what's been said here this afternoon, but I do want to emphasize New Future's strong support for this bill. From a public health standpoint, there's clear evidence that inequities and disparities around income, health care, housing, and other factors disproportionately affect people of color and women across our state. Data from the U.S. Census Bureau shows that Granite Staters who identify as African American or Hispanic, among other communities of color, report significantly lower income and higher poverty levels than the statewide average. These disparities extend to education, child care, housing, and other social determinants of health, and they deeply impact the health and wellness of our entire state. To address these inequities, it's critical that all Granite Staters, especially students, are welcome and encouraged to discuss them and explore the historical, cultural, and institutional forces that created them and continue to reinforce them each day. Without learning about these issues and exploring them in the classroom or in the workplace, neither our citizens nor our state will be able to address them or to support all of our children and families. With that, we encourage you to pass this bill, repeal this harmful ban on these important discussions, and to help our state move forward in becoming the kinder, healthier, and more equitable place that we all envision. Thank you, and I'm happy to take questions.
Thank you very much. Are there any questions from the committee? Senator Gannon.
Just a quick question. You were talking about inequities with color. So I remember my grandparents are all immigrants, poor, started at the bottom. Is that part of the reason? Is the income disparity more due to they're newer immigrants and so they're taking lower jobs and starting and moving up, just like our generations have done in America?
Oh, certainly there are a wide variety of factors, Senator Gannon, and I'm sure that's one of them. But I think, historically and contemporarily speaking, I think there are a wide variety of again, historical and institutional structures that reinforce these disparities that we're seeing. And we're talking about, again, when we talk about, we're talking about access to schools, access to healthy foods. These are, we're talking about location of neighborhoods, location of community resources. I think there are, yes, a wide variety of factors that contribute to it.
Madam Chair?
Yes, quick follow-up.
With disparities with women. So my sister was the first partner at one of the major firms in town here. Sure. And then she took a step back more to be with children, as have my wife and other people, their careers. Do you think the inequity in income is more due to, a lot of women choose to be nurturers at home? I'm not saying one will. I'd love to be a stay-at-home dad if I could, but it didn't work out that way. Do you think their economic income disparity is more due to they chose to stay home, they left good jobs in to stay home and raise the family, and their choices more than, I look at everyone I know can go do anything. My son's in admission at Penn, they take every race, they just are looking for the best and the brightest, as I usually am if I'm hiring anyone or someone's hiring me. So do you think these inequities that for equity, you're playing with the figures a little bit is what I'm saying?
I certainly, again, Senator, I think that there, this may be the case in some cases, but I think that you also have to look at, I think that some employers may look at certain applicants and make conscious or unconscious assumptions that is the case.
Thank you.
Yes.
Okay, are there any further questions? Seeing none, thank you very much for your testimony.
Thank you so much.
Next, we have Devin Chaffee, and then after Ms. Chaffee, we have Jonah Wheeler. I'd like to remind you, we can probably only be here for another hour. So I would just like all of you to think about your testimony, how much you're going to testify to. I know a lot of you here are testifying to industry-specific issues that you have with the past legislation and why you support this bill. But just be aware that we want to let everybody have an opportunity to speak. So thank you very much.
Thank you, Madam Chair, and other honorable members of the committee. For the record, my name is Devin Chaffee, and I am the Executive Director of the ACLU of New Hampshire, and I'm here to testify today in support of SB 304, as the Banned Concept Act that currently is on the books is unconstitutionally vague and being challenged in New Hampshire federal court in 2 lawsuits currently. The Banned Concepts Act that passed as part of HB 2 last year is so unclear and vague that it fails to provide the necessary guidance to educators about what they can and cannot include their courses. And you heard a lot about this from Ms. Tuttle earlier. This ambiguity invites arbitrary and discriminatory enforcement. And I want to provide a little bit of a historical context here that also sheds, I think, some light on the meaning of the concepts that are described in the statute. The New Hampshire Banned Concepts Act includes 4 of the 10 banned concepts of the executive order that was signed by President Trump on September 22nd in 2020. And here I want to be clear, especially in light of Senator Gannon's questions around what does this actually mean, what are these concepts actually trying to get at. The memorandum that implemented Trump's executive order made very clear that the banned concepts that are included in the New Hampshire law are intended to target the use of terms like white privilege, like intersectionality, like systemic racism, racial humility, and unconscious bias. So if you look back at the memo describing what these concepts were originally written for when they were in that executive order, that is how it is described. Now, partially enjoined that order because it found it to be so vague that it was impossible for plaintiffs to determine what conduct is prohibited. That's what a federal court judge decided. And so I don't think that we should be surprised at the testimony that you're hearing today that employers and teachers and educators throughout New Hampshire are also finding it impossible to determine what conduct is prohibited by this law. Rather than curing the ambiguities that were identified by the federal court, the New Hampshire Banned Concepts Act imposes penalties for violating its vague provisions. In fact, very stiff penalties. One remedy for a perceived violation is civil action in superior court. And so what this means is that any student or the parent of any student that is assigned a book that they think is prohibited by the law could file a lawsuit against a teacher's school and potentially a teacher themselves. The Act also provides that violations by an educator shall be considered a violation of the Educator Code of Conduct that justifies disciplinary action by the State Board of Education. And so a violation could in fact lead to the revocations of an educator's license to work in the state, essentially ending an educator's career. And so because of the vague language and these stiff penalties in the banned concepts, as we have heard here today, educators are already avoiding important topics concerning race and gender. And I do want to discuss a little bit, again, getting to some of Senator Gannon, your previous comments, about what is it that this bill is in fact intended to target. Yesterday, I was before the House Education Committee, and there the House chair made very clear that his understanding was that the bill that was passed last year was in fact intended to prohibit many of the discussions that we have talked about here today. And I want to be clear that this harm is already happening. I mean, we're already seeing teachers that have been influenced by this law that are not changing their curriculum. And so here I have with me 2 books that have been implicated. We have Tiffany Jewell's. This book is anti-racist. Is it banned under the Act? And we have a book called Stamped for Kids, Racism, Anti-Racism, and You. Is this banned under the Act? These are well-acclaimed books. This book is anti-racist, is a #1 New York Times bestseller. But no one knows if they're permissible under the Act. And in fact, the Commissioner of Education has suggested that they may very well be prohibited by the Act. No one knows, and the state will not provide concrete answers as to whether the specific texts are covered or not. And as a result, to avoid the Act's stiff penalties, teachers are currently, right now, in schools, pulling books from staff and course instruction because they are afraid of liability. I want to give a couple of concrete examples because I think examples were asked for. This book, Stand for Kids, was planned to be used in an interdisciplinary unit of study in a Cheshire County middle school, but it was placed on indefinite hold after the act was passed. A high school social studies teacher in Hillsborough County has disallowed students to pick their own topics for research paper because they are so afraid that those topics chosen by students might lead to discussions in class that are going to violate the act. A social studies teacher in Cheshire County put on hold a review of their curriculum to ensure more experiences of Black, Indigenous, and other people of color were represented in their American history units because they were afraid that if they did so, they would violate the act. This law is having a real impact on the ability of teachers to do what New Hampshire needs them to do, and that is to teach. And because of that, students are missing out on critically important discussions in the classroom. Education focusing on race, gender, and diversity and inclusion concepts in the classroom is important for everyone, and is particularly important in New Hampshire as New Hampshire becomes more diverse, as was made clear it is becoming in the recently released 2020 census. Instruction on race and gender, including diversity, equity, and inclusion concepts, serves to close existing opportunity gaps and inequalities faced by students of color in New Hampshire and other historically marginalized groups. It also helps these students to feel a better sense of belonging in New Hampshire. Finally, the Banned Concepts Act is simply put about censorship in schools. Censorship is a dangerous concept. In schools, we should be allowing ideas to be discussed, even those that we do not agree with, so that students are exposed to alternative perspectives and taught to evaluate issues for themselves. But through the Act's chill, students are and have been robbed of the information, ideas, and instructional approaches that would prepare them to engage in the robust dialogue and analytical thinking that is needed to effectively function as citizens in American's democratic system. And for these reasons, I respectfully urge the committee to recommend that SB 304 ought to pass. Thank you.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Senator Gannon, then
Thank you.
Senator Whitley.
I'll go back to you in the final version of the Senate bill. And when you were talking, two questions. One, when you were talking to the chair of the House, I think you said you were talking to him. Was he talking about the House version or the final passed version that the government?
The chair of the House, he was speaking in a public hearing yesterday, and he was speaking about the final version that passed.
Okay, thank you. Secondly, I'll go back to that part that Senator Khan started me off on, where it says nothing in this section shall be construed to prohibit discussing. Basically, it says you can talk about anything academic instruction. Wouldn't that allow these books?
Are you talking? Sorry, Senator.
I'm sorry. So, yeah, the nothing in the section shall prohibit discussing as a part of a larger course of academic instruction the historical existence of ideas and subjects. So isn't it fairly clear that you can do these things? Again, it's that advocacy point, which would be a bridge too far.
That Thank you, Senator Gannon, for that question. First, I think it is very telling that the statute does not simply use the word advocacy, that it uses that students shall not be taught or instructed. So it is not using the word advocacy, it is using much broader terms. And I think this was mentioned before, that is part of what is creating these concerns in the schools. Another important thing, I think, to note about the provision that you mentioned, Senator Gannon, about, well, you can discuss the historical existence of ideas and subjects that are identified here, but what about beyond that? And I think trying to draw that line in the classroom, you are finding teachers finding that almost impossible. How do you teach history without teaching how it applies to what is happening in the present, or the students' hopes for their future, or their own personal experiences? We're well-established best practices in the social studies to allow students to understand past experiences. You apply them to what's happening today, you apply that to your own experiences. And teachers are afraid to have students do that because they're afraid that they will be in violation of this law with the penalties that are so severe.
Thank you.
Senator Whitley.
Thank you, Madam Chair, and thank you for taking my question. So when we were discussing this legislation throughout the budget process, because it didn't have a public hearing when it was passed, we warned the majority that litigation would happen, both based on the ambiguity of the statute and based on the potential chilling impact. So those lawsuits have come, and I know that there are a lot of organizations that are part of this litigation. So I'm wondering if you could share who's involved in this litigation, what organizations, what parties?
Yes, Senator Whitley, I would be happy to do that. I would also like to say that our legal director is not able to be here with you today because unfortunately he was tested positive for COVID earlier this week. So that's why I am pinch hitting today. So please, I will follow up with you if I'm not fully up to speed on everyone who is involved in the lawsuit. But currently, the ACLU is representing a number of different organizations that are engaged in one of the lawsuits. One of the lawsuits has been brought by the American Federation of Teachers. The other lawsuit is being brought is where the individuals are being represented by the ACLU. The other entities that are engaged in the lawsuit is GLAD, which is the GLBTQ Legal Advocates and Defenders, the Disability Rights Center for New Hampshire, as well as the NEA, of course, and you heard from the NEA earlier. And if I am missing anybody in that list, I will certainly get back to you with a complete list of the plaintiffs in that case.
Thank you.
Are there any further questions? Okay.
Madam Chair.
You have a question?
I would just make a comment. You're hardly a pinch hitter, Ms. Chafee. Thank you for your testimony.
Thank you, Senator Cohen.
Okay, at last call, are there any further questions for Ms. Chafee? Okay, seeing none, thank you very much for your testimony.
Thank you, Madam Chair.
We are going to have Jonah Wheeler, and then after that, we are going to call Asma El-Houni.
Thank you. I'll try to keep it short and sweet for you, Senator Carson. I come before the committee today as a member of Rights and Democracy and a student who has spent his whole school career in New Hampshire public schools. I support SB 304 because without Ms. Judkins, my third grade teacher, who taught me about the brutal history of how the state has treated black and brown people and subsequently the working class, I would not be here with you today. And I mean with you alive today. Growing up with no one, not a single person around you, who looks the same or has lived the same experience is incredibly isolating. And it's far too easy for us who have always seen ourselves in those who are our mentors or teachers to say, oh, racism was solved in the 60s, now we can just stop talking about it and it'll go away. I've met with teachers from my district of Conval, my former high school district of Conval, who are already feeling this chilling effect that many have talked about from the divisive concepts legislation, moderating their speech, their curriculum, and the conversations they have with students for fear of prosecution or other consequence. I think of the young black people with white families like me going through a similar, if not worse, situation as I did. Feeling currently isolated in the town you grew up in, not letting their teachers teach that student's history, solely because we here do not want anything negative said about our country or its history, is leaving behind those students who need to hear that history in order to understand themselves. As someone who was fired for having so-called unconventional hair, as someone who faces and faced veiled threats from peers and have been called a nigger, I can assure the committee racism still persists in our society. Many peers of mine did not know until just last year, when it was viral on the internet, that in 1921 city officials had essentially sanctioned the brutal massacre of the black community in Tulsa. The mob burned prosperous black businesses, killed innocent men, women, and children, and brutalized the people of that town. Why should that not be taught at a high school level? The future leaders of our country should learn the horrors of our past so that they do not repeat those mistakes, as was said just before. Those who support the divisive concepts legislation and I think, agree on one thing. School is not a place for ideology or propaganda. School, especially the upper levels, high school, college, is a place for spirited discussion on the hardest topics of our time, allowing young individuals who represent the opportunity to avenge the dark part of our history the ability to shape their own perspectives, not letting a tampered history guide them towards ours. I believe that understanding the full history of where we've been is the only way that we will know where to go. Pretending that the practice of othering people has come and gone only emboldens the tiny minority of people who continue to other people. I love this country and all the people in it deeply. I believe in the potential that it has to move humanity toward a new modern era of peace. I don't believe in forced diversity or even forcing you to like me. I do, however, believe in a world where you and I can have conversations with passionate disagreements on where we need to go while maintaining a level of respect. And at the end of the day, sitting down together with comfort in knowing wherever we may go, we're going together. I think it's not just possible, but it is coming and necessary. I urge the committee to support this repeal. There are far more important issues than censoring the speech of educators. We mustn't isolate children or chill speech in institutions of education. I appreciate the opportunity.
So it's spelled ASMA, but it's pronounced like the letter ESMA, ESMA. And it kind of has to do with what's happening today. I don't expect you all to understand our experiences, and that's why this bill is really important. So I'm going to start off with, I speak to you today in my capacity as Rights and Democracy, but also as my lived experience as a minority in this country. I am a Muslim and also a brown immigrant who lives in the United States. I'm here to share my support for SB 304, which would protect school teachers, educators, and also government officials to be able to teach about true history, but also racism and how it is actually manifested in our society institutionally and structurally, because that is very real for us. And I'd like to explain why this bill is so important to me, to my community, but also all of us. When I was a child, my parents came to the United States on asylum, and they hoped that my brothers and sisters would be safe, including me, and they went to a country that promoted equal rights, human rights, freedom, and equal opportunity. But unfortunately, what we promote and what is actually happening is that these rights are not given to everyone. I could tell you stories of when I was younger and I was called sand, this is a really bad word, but sand nigger. This is what I was called when I was younger. And being made fun of because of my religion and where I come from. What was even more harmful, though, is every time I turned on the television, watched news, read books, seen anything that had to do with people that were Muslims, it was oftentimes negative. And there's research to back this up, so it's not just my experience, but we have people who've actually studied and saw that whenever Muslims are portrayed, most of the time it's in a negative light. It was also incredibly harmful seeing my community treated as a threat by law enforcement and the security of our nation. I would like to share with you all why there is this othering of people like me. First, Muslims only make up 1% of the population in the United States. In New Hampshire, we're only 0.1%. Because everything people see and hear and read, and we just talked about the media and books, are negative portrayals of Muslims, they portray us because they don't know a Muslim personally. Most people in the United States, they automatically portray us as violent or the stereotypes that they read about us. So it's really vital for people like me to teach about what's going on institutionally and structurally to my people. I didn't share this yet, but there's other things that happen structurally. Like, for example, even though research has shown we are not violent people, the majority of us, but we know the stereotype is that we are violent, right? And so research has shown we are not the group that commits the most violence, but oftentimes we are the ones that are pulled at airports. Our mosques are surveillanced. We are on no-fly lists. We get caught up in things called entrapment. We're surveillanced. And so all these things are institutional and structural racism. I am not blaming people for feeling a certain way when all they know is what they see and they hear, as I mentioned, right? But it is my duty, for the sake of me, for the sake of my children, and for the sake of all Muslims, that I educate people. And then it is a duty for other people who hear our stories to educate other people. We cannot change society if we do not know what's wrong with it. I do not expect you to understand or just know the things that I go through or the Muslim community goes through without me being able to say, hey, look, this is what's going on with us. And I'm not saying that people are intentionally being harmful to us. Again, most people, when they know, they do better. So what we're asking for right now is to be able to say, hey, look, structural racism is real. Institutional racism is real, and we have to talk about it. Laws like the ones passed last summer serve to censor our classrooms and shut down important conversations that we need to have to overcome biases, discrimination, and systemic barriers. I support SB 304 because it'll protect education that we need in order to understand the harms of the past and the present and build a true multiracial democracy where everyone, no matter what race, no matter what gender, can thrive. And I'll also say, because you might hear from people that are minorities and they might be in support of this bill. So I'd just like to give you a quick example of, like, say, my mother. I will speak very differently than my mother. My mother is an immigrant, and she will say, I love this country. And the reason why she says, and I love this country too, and I believe it's love that's making me stand here and the hope that we can be better and we can. People in the past, we've made mistakes, they've gotten better, and we have that opportunity now too. So what I'm trying to say is my mother would say, this country is great, she won't complain, and she'll even say that she's never been discriminated against when I myself have seen her being discriminated against, right? All that to say is she's comparing it to a place she comes from, where I come from as well, Libya, and so that's where she's going. And so I think it's just, it's a low standard, and she's saying that because she's thankful that she's, out of the harm that she was in, right? But it's important to note that that should not be the standard. We need to get better, and as a nation, we can get better. And I'd like to, if you have any questions or anything.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Seeing none, thank you very much.
Thank you.
Next, we're going to have Barrett Christina, and then after Mr. Christina, we're going to Katie Morrow.
Thank you, Madam Chair. Thank you, members of the committee. For the record, my name is Barrett Christina. I'm the Executive Director of the New Hampshire School Boards Association. The New Hampshire School Boards Association is a private nonprofit organization with 161 school boards as dues-paying members. We are in support of Senate Bill 304. I did email the committee initial testimony last night. I don't know if you received that yet. I did follow up with another email to the full committee this morning after I slept on it and woke up this morning with a couple other thoughts. I'm not going to read our entire testimony. Ms. Horgan is kind enough to pass that around. But primarily, one of NHSBA's bedrock principles is local control over local educational matters. Our positions are determined by our members at our annual delegate assembly, and I've listed in our testimony 4 or 5 longstanding resolutions and 1 new resolution that speak to local school boards having local control over local curriculum and local educational decisions. Most recently, at our October 2021 Delegate Assembly, the issue of the language in the bill that was embedded in House Bill 2 last year came to the forefront. We had at least 2 school boards submit proposed resolutions asking NHSBA to take a position against that specific language and to reiterate our longstanding principles and longstanding resolutions that local school boards should be in charge of local curriculum and local educational matters. So the one that I would like to read is on page 1. I won't read all of them. It says, NHSBA supports diversity, equity, and inclusion in all aspects of our schools, is committed to the concept that free and open dialogue around such concepts as racism and sexism is a vital component to education, and opposes any actions which limit this free exchange of ideas. That's the most current resolution that our members have passed. Further, on page 2 of NHSBA's written testimony, I've highlighted a handful of current state statutes and Department of Education rules that already place local education decisions in the hands of local school boards. Elected school boards shall be responsible for the delivery of instruction and shall support diverse educational approaches. That's RSA 189:1-A, paragraph 2. The adequate education statute that is required under the New Hampshire Constitution, RSA 193-E:1, paragraph 2. Schools then have the responsibility and flexibility in implementing diverse educational approaches to instruction and curriculum tailored to meet student needs. Additionally, in the adequate education statute, it's the responsibility of school boards to implement, to determine the course of offerings, and to choose the methods of instruction, the activities, and the materials to be used. So at its most basic level, the language that has been embedded in House Bill 2 runs contrary to existing statutes relative to the right of school boards to determine local educational matters and the right of school boards to determine what curriculum and how it shall be delivered in their local in their local schools. Additionally, a couple aspects that I would also like to highlight is that I believe Ms. Tuttle may have spoken about this. Educational organizations, teachers specifically, have reached out to the Department of Education repeatedly since the language in House Bill 2 became law, asking for further clarification as to what can be taught and what cannot be taught, how it can be taught, and how it cannot be taught. The Department of Education, I believe in conjunction with the Human Rights Commission and perhaps the Attorney General's office, did issue a technical assistance advisory, I believe the middle of August, if I'm not mistaken. That answered some questions, but that did not answer all the questions. So I think the fact that so many people here are supporting this bill, especially teachers who have continuing questions about what can be taught, what can't be taught. Administrators have that as well too, trying to navigate that balance between their assisting the school boards while overseeing their local staff. And further, NHSBA has received dozens of phone calls in the last 6 months or so asking what we should do about this. How do we go about addressing this issue? How do we go about making sure that our teachers and our school district is not running afoul of the law? The answer NHSBA has given, there have been a couple of different answers NHSBA has given. First, we've said review your curricular materials, review your professional development materials, review what may or may not be in your library. But the most basic answer when we ask is, what does this mean, or what does this provision mean, or what does this statute mean? We say we're not going to know what it means until a court tells us what it means, and we're already on that way. So with that, that's the bulk of NHSBA's testimony in our written guidance. I would like to address a couple questions that I believe Senator Gannon, you brought up. And I'm looking at the current law, I have it here in front of me. I didn't print all of House Bill 2, obviously, and I didn't print every provision that Senator Kahn's bill does address, but I'm on page 147 of last year's House Bill 2, line 23, the provision about 193:40, prohibition on teaching discrimination. And Senator Gannon, I think you've spoken about, you're interpreting this to mean you can teach about it, but you can't advocate for it, if I'm not mistaken, sir. It's a yeah. Thank you, Senator. I'm just reading. I'm reading the provisions of 193:40, paragraph 1. No pupil in any public school in this state shall be taught, instructed, inculcated, so on and so forth. We can based on statutory construction, because we have those commas and the word or, we know we could read that provision to mean no pupil in any public school in the state shall be taught that one's age, sex, gender, identity, sexual orientation, so on and so forth. In the provisions in RSA 193:40, if I missed it, I don't see where it talks about advocacy. This says they cannot be taught about those things. The contradiction comes in paragraph 2 of RSA 193:40, where it says nothing in this section shall be construed to prohibit discussing as part of a larger course of academic instruction the historical existence of ideas and subjects identified in this section. So we are not prohibited from discussing it in paragraph 2. We are prohibited from teaching it in paragraph 1. I don't know how to rectify those two provisions. And last, Senator Gannon, sir, you asked, again, it may have been Ms. Tuttle that you posed this question to, about what would be the middle ground, because I believe you had some earlier comments that you thought perhaps Senator Kahn's bill was a bit too broad. NHSBA would advocate that the middle ground would be simple repeal of the provisions of House Bill 2. I know there are repeal and repeat. We support this bill because that's how it's been presented, but the middle ground would be simply to repeal the language that was embedded or included in House Bill 2 last year. And with that, I conclude my testimony, and I'm happy to answer any questions from the committee.
Thank you very much for your testimony this afternoon. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you very much to all of you.
Next, we're going to Katie Merrow. And then after that, we are going to go to, let's see, I think it's C-H-A Chow Kelly? Is that correct? Okay, good. Thank you.
Good afternoon, Madam Chairman and honorable members of the committee. Thank you for the opportunity to testify. My name is Katie Merrow. I'm Vice President of the Community Impact Department of the New Hampshire Charitable Foundation. The Charitable Foundation stands firmly behind the belief that our children deserve an education that promotes their development, their critical thinking skills, and offers them practical tools for the future. As such, we urge you to pass Senate Bill 304. I have 3 points I'd like to make, and I thank you for your patience. I know you've heard lots of good testimony and points made today. First, our nation has a complex history, and New Hampshire students have the right to learn the good and the bad of it, the bad elements of that. The current law makes it difficult for students and teachers to have honest and accurate learning conversations, and it limits our progress with discussion on topics like sexism, disability, gender identity, and the systemic racism that's bringing harm and limiting our progress in communities. Secondly, and this has been mentioned earlier, the current law is unclear, and teachers are understandably confused about it, and most importantly, they're concerned for their jobs and their reputations if even one parent complains, rightly or wrongly, about a book or a film or a historical document included in their curriculum. Our children will miss out on a complete and accurate education if educators are worrying about complaints and lawsuits for teaching about racism or slavery, or for just allowing students in the classrooms to share their experiences honestly. Third point, and I'm sure you've heard from business leaders on this today, the future of our state and our shared prosperity depends on having a state where all people are fully welcomed and able to thrive and help sustain our communities. The current law puts us in New Hampshire at risk of being perceived nationally as an inhospitable place for people who seek a welcoming, inclusive, and diverse place to live and learn. Given the workforce challenges that we know our nonprofits are facing, who are serving in all of our communities and also in our businesses likewise, we can't afford to have a reputation that discourages people from coming to New Hampshire or from staying here. So the SB 304 provides a straightforward and clear way to course correct for our state and will give our children the education and skills they need to thrive in our communities, in civic life, and in their careers. And we urge you to pass it. And I thank you very much.
Thank you very much for your testimony. Are there any questions? Seeing none, thank you very much.
Thank you.
Next, we have Chow Kelly. I'd like to remind everyone, we've had a lot of information, so please, new information, please don't repeat, please don't read. We'd like to get through and have everybody have an opportunity to speak. So please continue.
My name is Chow Kelly, and I live in Hooksett, New Hampshire. And I would like to let you know that I'm a political refugee. I came to this country from Vietnam, and my father was a Marine captain, fought alongside with American. He spent 7 years in the communist prison, and that's why we are here. And I'm thankful to God for this opportunity. And my mom was a teacher. And I have the utmost respect for teacher because the Asian value education and teaching the most. Teacher ran second after the king in our country, above our parents. And I have dreams to become a teacher myself as I was growing up as a kid. But my mom said, no, don't become a teacher, even though she was a teacher herself. But you know why? Because teachers in my country get paid like dirt. They cannot survive on the salary. So I had to become a business person in this country, and yet I follow my dream. I teach Vietnamese to the kids in the community to preserve their language, volunteer of course, and I teach people English to assimilate into this country. And I serve as the first Vice President of External Affairs of the Vietnamese American community in New Hampshire. I helped found it. I serve both Vietnamese and Massachusetts and New Hampshire. I've served for more than 20 years. So I am speaking from the big background of a political refugee. And I'm telling you, I'm here to oppose this SB 304. And I tell you why. I felt like I am in Vietnam again. I grew up in that system, that communist socialist system. And every time I come home and I recite these things on a hammock, my mom always corrects everything that the school teaching me is all wrong. And she could be arrested in prison, even though my father was already in prison for serving the country to defend freedom and democracy for 20 years for the South Vietnam before the Vietnamese communists took over the country by force. So my mom had 3 little kids, but she risked going to prison, speaking up, teaching me the right thing. So I'm not indoctrinated by that communist teaching. For showing up as rallies to open our country last year in May. I'm Asian American, and I support to open our economy to support us. Our job, our livelihood, and these people, why Caucasian American call me racist just because we have different political positions. It's not the color, it's the indoctrination up here. And the teachers fearing of losing their job. I tell you this, you should be fearing losing your children, all of your children, to this communist indoctrination. What they do is they're teaching all the children in your family to become a secret police in your family to report everything to the government. And they will become the prosecutor of you and each of your family member. The oppressed and the oppressor in Vietnam was the landowners are the oppressor, and all the farmers who don't have land, the oppressed. So they rise up, take out the oppressor so that they can rule the country. Guess what? Those oppressed people, they exactly are even worse than the oppressor. Their money banked in the Swiss accounts in the mountain, and most people live worse than during the time in the French colonization. So the thing here right now is racist. Why do we bring up racist now? I was in history class at Southern University of New Hampshire, way back then it's called New Hampshire College, and most of my class have absolutely no clue about the Holocaust. I came from Vietnam, and I knew about Holocaust, and most of my classmates had no clue. So that is a real history. Why aren't they taught about that? Why don't we teach real history? Why do we care so much about races? And kids talking about defund police and all that is supportive. Do you teach children in the school about Holocaust? Do you teach them about the Antifa on the front line that beat elderly people? I'm on the front line at rallies all the time. I'm covering these events. I'm a journalist. And I see them firsthand, but they don't talk about these things. Why? These are the real stuff, right? So you want to talking about just racist, why? Because it divides people. When you divide people, that's cause war among classmates, war among co-workers, war among neighbors and family members. And that's ruining our country. Who's behind this idea of this racist thing? They are dividing us to conquer. That is national security. So these teachers shouldn't be worried about losing their job. All they should care about is teaching real history. And you know, I have no clue and no understanding what gay mean until I came to this country, and I was like 20 years old. I was in college in Vietnam. And you know what? I'm like, what gay means? And you know what? Compared to the kids nowadays, in fourth grade, fifth grade, they know about things like anal sex. What the heck is that? Why don't we talk about those things? Stop those things. Ruining our children. You take away the innocence of the kids. Their future is so important. Why do we focus about racists? I shouldn't be here talking about, I should be here to support if you see about the color, right? But no, this is wrong. The thing we should bring back into school is God. I wish all the people in the state of New Hampshire, the live free or die state, bring God back into school. The U.S. Constitution is based on the Bible, and the founding fathers of this country are Christian, they're believers, and most of it is based on the Bible. So bring God back into school and destroy this SB 304. This is destroying the generations of Americans, the future leaders of our country. So thank you so much for listening. Oh, and by the way, people are talking about, oh, teachers don't feel comfortable teaching about that. It's not about you feeling comfortable. It's about not your comfort. It's about what's right and wrong. Teach science. Teach the real things. Don't advocate for kids to be violent. Don't incite hatred and violence. That gentleman there, Senator Gannon, he keeps saying that, and I keep sitting there and nodding with him like, you teach whatever is right, but just don't advocate it. You're a teacher. You have the most respectable professions. I love teacher. I respect, I miss, and I love all the teachers, and I respect you all, but please just correct that, and we'll be good. Thank you so much.
Thank you for your testimony. Are there any questions?
Oh, sorry.
No, you're good. No questions. Thank you.
Thank you.
Next, we're going to Karen Leot Hill and then Thomas White. Good afternoon.
Good afternoon. Thank you very much. Can you hear me with my mask on? Thank you. My name is Karen Leo Hill. I'm a 17-year city councilor from the city of Lebanon and former mayor. I am here today because over the past few years, the city of Lebanon has been embarking on diversity and equity initiatives. We recently created a diversity, equity, and inclusion commission. We also identified training that we wish to work on with our staff, with our city staff. And so I'm here today because the legislation passed last year has created a cloud of uncertainty. It has created ambiguities that have hindered our ability to move forward with some of those initiatives. I'm here to register support on behalf of the City of Lebanon for SB 304. And on a final note, I'm keeping my remarks much briefer than previously planned in respect of others who still wish to testify. But lastly, on a personal note, I'm also a mother of a high school student, a 10th grader at Lebanon High School, who is in a social studies class right now. And on more than one occasion over the past few months, They have come home and told me that the teacher has actually stopped discussions from happening, particularly as students have made connections between past, this is a world history class, so they're focusing on the past and making connections to things that are happening in present day. And as students have raised questions, the teacher has avoided having those conversations out of concern for potentially running afoul of the law. It may be that the teacher could have those conversations, but nonetheless, the impact is that the teacher is avoiding those conversations out of fear for running afoul of what I think is uncertainty and ambiguity. And so I wanted to end with that personal eyewitness testimony as to the impact that last year's legislation is having today, and to ask you to pass SB 304 on to the full Senate with a favorable recommendation. Thank you.
Thank you very much for your testimony. Are there any questions? Okay, seeing none, thank you. Next, we're going to Thomas White, and after Thomas White, we have Lily Tang Williams.
Thank you, Madam Chair, members of the committee. My name is Tom White. I'm the coordinator of educational outreach at the Cohen Center for Holocaust and Genocide Studies at Keene State College. And to keep my remarks short, we've heard today fears of teacher. I can cite examples from my interactions with the teachers. A teacher who refused to come to New Hampshire to apply for a job, fearing that they're going to be monitored. Of groups that are meeting in secret across the state to try to get support, fearing, and these are black teachers who are terrified that they're going to be targeted if they're seen discussing these issues publicly. So we have them now going underground for their safety and for mutual support. So I can cite example after example of that, but my perspective as a Holocaust and genocide educator is to look at other patterns. This also is consistent with other, I would call, anti-public education initiatives that are being undertaken currently in the state. The Loyalty Act that is now on the table about assessing a teacher's loyalty if they can only praise the good of America villainizes our classroom teachers. That's currently House Bill 12, was it 55? And in my field, as we look at teachers, you've heard the testimony today, teachers being terrified. The statute itself, I don't want to discuss. I don't want to discuss or debate what is or is not in the bill known as divisive concepts by some, because I don't think that's the point. In my field, we look a lot at initiatives that target. And in this case, this particular legislation is vague, and I can only imply I have no way to measure intent on purpose, because it has done the very thing it's intended to do, which I think is brilliantly constructed in its vagueness and ambiguity, and that is to mobilize anger, to target teachers, to have a website, our New Hampshire Department of Education website that has a link to inform on teachers who have violated some ill-defined ideological goal is terrifying. And it's part of an ongoing and growing process. So in my field, we raise certain questions looking at longitudinal problems. Yes, we've heard fears expressed of extreme leftist propaganda coming to the classroom, extreme rightist propaganda coming to the classroom, both, of course, which we reject. In our field, we're looking at the safety of public space. And what we're witnessing currently in New Hampshire is a contraction of public space, where schools and school boards are being harassed, intimidated. And I think that's the outcome of this particular type of legislation, including the proposed Loyalty Act for teachers. What concerns us, these are some of the questions we ask in our field about warning signs and risk factors of societies that are falling away from democracy and therefore raising risk for perpetration and targeting. Some of the questions we ask. Is there a targeted group? Is it facing organized violence? I would argue in this case, yes, it's public educators. Is the violence deliberate, systemic? Are there growing questions and distrust about democratic processes? Does exclusionary ideology exist? Are minority elites manipulating divisions amongst us? Are institutions being undermined, like public education? To what degree is there identity-based polar factionalism? Are institutions being fragmented along ideological lines? Are identities divisive or unifying? is education of younger generations under attack. We've heard all of that here today. And what we're terrified of and very concerned with is the destruction of public space. And that destruction of public space includes the ability to not only discuss divisive topics, but to assess history. We heard a lot today about advocacy versus teaching and how vague all that is worded. And I think advocacy is not part of this. And then who would decide what's advocacy, what's teaching? I feel for your children who feel targeted for their opinions. As a former professional educator myself, I was a high school teacher for 16 years. That would be anathema to anybody's professional calling, and a teacher would be terrified to hear that was going on. We share that. The public space is sacred for all views in America. And what we're seeing, though, is that being taken away, being restricted, when teachers are going underground to try to find mutual support due to people who are going to our website at the New Hampshire Department of Ed to destroy their teaching credentials without any evidence, then we have a problem. And so that's a brief summation of the kind of things I was going to talk to. But I just want to say that our schools and our school boards that are facing intimidation and fear are the safe spaces we desperately need to protect. And we heard that from those from the left, from the right, and in between today. And that is what we're losing. And we're seeing that not as a singular document, but as multiple attacks that are ongoing and growing. And we have stuff to be frightened by.
Thank you very much for your testimony. Are there questions? Senator Khan.
Yes, I'll just ask one. Mr. White, you are instructive as usual, and your way of dissecting what you've witnessed over your time with schools is insightful. You probably spend more time in schools than anybody I know, meaning an outsider going into schools to talk about issues that are discussed in this legislation, in the current statutes. Have you ever come across anyone teaching critical race theory?
No. No. No, the answer is no.
Has anyone ever asked you about that kind of curriculum in your discussions?
No. No, the answer is no.
Yeah. Okay, thank you.
Are there further questions? Mr. White, I find your testimony very interesting. I've sat here for most of the afternoon and I've listened to what people have said. And it's an issue that I've been following for quite a while. This is not a new phenomenon. And I think what we're seeing is problems that have been festering underneath the surface are finally coming forward. And that's on both sides, both from the far left and from the far right. And I come from a community that has a great school system. We got great teachers. But I've found out that, in my opinion, the problem is coming from the school board. And it's because the school boards are not listening to the parents. And the parents are getting angry. And I think that's what you're seeing, is parents who you want to advocate for their children. They are their children's biggest advocates that aren't even allowed to speak. And they're being intimidated by police being called in when nothing's going on other than parents getting up and talking about their children. And I do think we need to really take a look at what is going on. So again, I appreciate, this is more of a comment in my own personal observations. We'll probably see more legislation like this. Parents want to be involved in the education of their children, and they're just not being paid attention to. So, again, I look forward to corresponding with you and hearing from you again. I think I agree with Senator Khan, very reasoned, very moderate kind of an approach, which I think is something that we need today, because everyone's being torn by far left and far right. And we've got to try to get back to the middle, some way, somehow. And I think it begins by listening to the parents.
Thank you, Madam Chair. And if I may comment, as a public educator, that was always our goal and objective, the more we can get parents involved in the education of the curriculum, the stronger the school district was. And I think we've all experienced that in our lives. Unfortunately, the trends in these kind of laws do the exact opposite of that. When you're talking about using back channels in the Department of Ed website to inform on teachers, and you've heard the chilling impact that this has, that isn't involving parents in a classroom. It's setting parents against teachers, trying to identify a particular moment where some egregious and ill-defined action has taken place. It's the opposite of involving teachers with parents in a classroom setting. And so I think these things go exactly what you said, against that kind of cooperation and investment of teachers with their parents in schools, which is a long-standing and rich process in New Hampshire with local control. We have teachers often working with parents, and it's the strength of New Hampshire education. Unfortunately, this kind of legislation does the opposite. It pits people against each other, and as you've heard today, makes teachers absolutely terrified and less likely to even talk to parents about those kind of issues.
I think on some points, again, and I'm not going to argue with you, that we agree, and some points we disagree. But I appreciate you being here today and giving us your thoughts. Thank you very much.
And thank you, members
Are
of the
there
committee.
other folks that has comments, questions? Okay. Seeing none, thank you very much.
Thank you.
Next, we will have Lily Tang Williams, and after that, Dan Itza.
Thank you, Madam Chair, and thank you, Senators. I'm Lily Tang Williams. I'm a Chinese immigrant from mainland China. I also represent our New Hampshire Asian American Coalition. Believe it or not, we are the second largest minority group in the state of New Hampshire, 3%. And we had a rally last April called Stop Critical Race Theory Indoctrination, organized by us. We had 250 to 300 people showed up to support us. And we had a wonderful, beautiful ending with 10 immigrants on the step of our Concord State Capitol right here, hold a sign in their native language, from Chinese, Vietnamese, to Hebrew, to Thai, to Japanese. You know what they're saying in their own language? One simple sentence from our founding fathers' document, Constitution. All men are created equal. If you don't believe it, we will show you the video. And also, I wrote an open ad before that, a Chinese immigrant warning on critical race theory. Personally, I was born in China. I did not leave that country until I was about 24 years old. I came here without speaking English like I do today here, and with $100 borrowed. Why? Because I had to flee oppressive, the largest totalitarian government today, for my freedom. And it's a long story. I finally come to New Hampshire because I believe our motto, live free or die. And by being a Chinese immigrant, it saddens me to see what's going on in our country today. Division of the society. Parental rights voices are being silenced. Everything's about the race. It's about equity, diversity, and inclusion. You know, we recognize those terms. From the communist country, equity is a communist term, Marxist term. Especially when Black Lives Matter founder organization, I'm not talking about the movement, I'm talking about the founder come out to say, we are trained Marxist. Don't you think our immigrants like me are terrified to hear that? That's very scary. We escaped communism, socialism, Marxism, come to a free country, and our kids today, byproducts of you call it public school education, They don't know any of those horrible evils of communists. They even were chanting, we want a communist revolution. We want more socialism. We want to free this, free that. That's what they promised us under Mao. If we just have communism, everybody will be happy. Utopian will be here. The truth? Nothing can. I was a starving child. I had to eat the red meat to satisfy my hungry stomach. And you tell me that, critical race theory is not being taught in our schools? Just look at NEA, the largest website, the largest teachers union in the country, passed the budget last June to say, we are going to have a budget to push critical race theory into 14,000 public school districts. We have a budget to go after community leaders, parents, and think tanks who oppose this. Well, if our free state to say, hey, we're not going to teach that, good. I applaud for you. Please come out, make a public statement. Our teachers union in New Hampshire, or whoever supports them, to say, I oppose teaching critical race theory, or different name. It's called DEI, diversity, inclusion, equity. As I said, those are the terms we heard before. Under Mao, he used critical class theory to divide all Chinese citizens into oppressor versus oppressed. Sounds familiar to you? And under oppressor, it's a capitalist, landowners, intellectuals like our teachers and professors who dare to disagree with the party, labeled black classes. And me, a red child, totally brainwashed to say, hate them, hate the black classes people, because they dare to question Mao, question Communist Party, which is one party rule, and they're trying to destroy our country. I was 12 years old when Mao died. That's when I started to question, who lied to me? I self-censored. I could not speak the truth. By me being here today, exercise my constitutional right as a citizen of this great country, demonstrate, America is not a systemic racist country. We reject that premise because you tell me why, if it is, why many immigrants want to come to this country, why they want to come here with nothing, take life risks to get here to achieve their American dream. We're not oppressed. We're not victims. We love this country. We love people of New Hampshire. We love you all. Can we just please talk more about being united? Instead of everything is about race, everybody's about skin color. Have you talked to parents who oppose this bill? Have you interviewed students in Hollis High School oppose this bill? Every time when some social activist teachers, most teachers are good. Some teachers are social justice warriors. They are indoctrinating our kids. They're making our kids feel depressed, feel hate their country. They don't even want to go to school anymore. And a parent in Hanover, he testified before, talk about his story. He said he got homework from his kid's school in his area, asking him as a white man to apologize for his whiteness, for his racism. It's so sad to me, our country divided like this. It's nothing new. I'm terrified. If you are talking about teachers terrified who cannot teach real history, which I believe is not true, we support this bill. We actually testified to say you can teach horror of communism. Lots of teachers don't. I've been kept out of public schools to teach kids as eyewitness of Mao's Cultural Revolution in China, living there for 24 years. Nobody wants to invite me to go there. I'm not real history, I'm a living history. And our teachers even tell me, Lily, we don't know about what happened to you under Mao. More people died under Mao, under communism, than people died in Nazi Germany, in all those wars. Do you know the truth? So when you talk about this teach real history, yes, I totally support that. I also know about civil rights movement. I know about MLK who wants his children to be judged only by skin, not by skin, but by the content of his individual character. I totally support that. But are you teaching that? Are you teaching MLK civil rights movement? I agree that slavery was horrible. And individual racism still exists. Not good. Get rid of it. We want to love our citizens. We want to be united. We don't want to look at each other by how they look, what skin color they have. I'm yellow, I'm Chinese. What category do I belong? Oppressed or oppressor? I love this country so much. Every time when I get the opportunity to testify, I will. I also invite teachers to call me, contact me, our association, our coalition, to say, what are other immigrant stories there? We want to hear all sides. Don't take my words for it. Verify yourself. That's what teachers are supposed to do. Teach our kids to be independent, critical thinkers. Instead, like me, was indoctrinated by a government school in China for 20-something years. So I will appreciate if you can call me or email me. You can find our coalition Facebook online, New Hampshire Aging American Coalition. I'm the co-founder. I will have lots of immigrant stories like that. And appreciate your time. Thank you.
Thank you very much. Thank you very much for your testimony. Are there any questions from the committee? Okay, seeing none, thank you very much.
Thank you for your time. Have a good day. By the way, February 1st is Chinese New Year. And all happy Chinese New Year.
Happy New Year. Dan Itza? Okay, I don't see him. Okay. Heidi, and it looks like CWMNINE? Okay, and after that will be Kathleen LeClaire. Good afternoon. I'd just like to remind you, we've heard a lot of testimony, so please do not repeat the testimony. If you've got something, please don't read it. I don't want to start instituting like a 3-minute rule or something, so please try to be very concise. We have quite a few other people who would like to speak.
Sure. I type something up and I'll leave it
Yes,
here for
please
you
do
guys.
that. We're not execing this today, so we will have plenty of time
No
to read.
problem. I might refer to it to make sure I get a few things, but I'm not going to cold read
Okay.
it. My name is Heidi Crumrine. I am the 2018 New Hampshire Teacher of the Year. I am an English teacher and literacy coach at Concord High School. And when I got here earlier today, I was afraid I was going to have to tell you how I got here during the school day, but now it's 4 p.m., so 4:30. No, I came on my planning period. I guess that if I have to summarize, that it's really a chilling time to be a teacher in New Hampshire right now. And I'm really delighted to be here. And I guess I would say that on paper, HB 20 does seem reasonable and welcomed. Don't we want teachers who marginalize students to receive consequences? And I would say an absolute yes, and that none of my colleagues or anyone who I work with would ever defend an educator who targets, marginalizes, demeans, belittles. But this bill, as it was passed last year, is not about protecting students. It's really just making teachers feel as though they are on a constant microscope for trying to teach and engage students with what we know how to do because we are trained and experienced educators. Also frustrating is that there did not ever seem to be conversation with and for and among educators invited to the table to talk about this bill. And so it's also frustrating that these kinds of hearings occur during the school day when we can't come. So I would hope that if you're going to continue to have legislation that affects us so directly, to please have it during a time when we can be here. I would highlight that in response to the legislation, instead of advocating and supporting us, the Department of Education has published that form that I know you've heard about. Anyone can fill it out for an alleged violation. and the DOE advertises it as a way to protect students and teachers. And the Commissioner Edelblut has even suggested that it is a formality and that teachers should understand, that schools should not be concerned because this happens in the business or the real world. But it's not the same. It was published without warning. It was published without input, and it supports a goal that the public didn't support, and it was hidden in a budget bill. There haven't been, it feels, any constructive conversations about what is actually happening in New Hampshire classrooms. And I would ask, when was the last time that anyone who crafted this legislation was actually inside of and participated in a classroom in New Hampshire? When was the last time that any of you were? And if it was when you were in high school, that doesn't count. Pathways for families to file complaints and concerns already exist. And so I think that this is more than just a formality, and it can't be a coincidence that within a week of releasing the form, the nationally funded fringe group Moms of Liberty put a bounty on teachers by offering $500 to successfully catch a teacher. And so I guess I will end with just a few stories, one line, don't worry. But teachers have told me stories, one who received a death threat because he taught the history of slavery. A teacher who was contacted by the FBI because their name was on a watch list circulated by the Proud Boys. A teacher whose Rosie the Riveter poster was taken down by students because they thought it represented feminism. Teacher who was told to remove all LGBTQ stickers and signs in their classroom. An administrator who said to a group of concerned teachers that they support what they're doing, but if you're reported via the DOE form, there's not much they can really do to help. The administrator who told a teacher they're afraid to combat an increase in LGBTQ bullying because of the blowback from fringe groups. Or my neighbor, a teacher who decided not to teach about Thanksgiving in the same way simply because it didn't feel worth it. One word and I'm suddenly under investigation. I'm now reconsidering everything. And I would say that her words capture what all New Hampshire educators are feeling right now. We're reconsidering everything, and not in a good way, and not what this bill intends. These are real teachers dealing with real students in real New Hampshire classrooms, and they need us. They are struggling to make sense of the world that they live in, and we are being silenced by a bill that does not do what is it intended to do, and frankly, probably deters people from even wanting to enter the classroom in the first place. So, we are at a crossroads. Do we want in New Hampshire strong public schools that retain top-notch teachers? Do we want to stay at the forefront of innovation as we have for the last several years? Or do we continue to pander to extremist groups that don't really know what's going on inside our classrooms? In fact, I've worried today in crafting these remarks. Am I putting a target on my own back? Am I going to be retaliated on that DOE reporting form? Will the Moms of Liberty bounty come for me? Am I going to get a phone call from the FBI? Is that what you want the teachers in this state to be worrying about? So I believe in our schools in this state. I believe in our teachers, and I believe in our students. Legislation that incites fear and prevents exemplary teaching is not what we need right now. What we do need is a laser-like focus on equitable access to all students in New Hampshire and a seat at the table for policy decisions about our profession that we love so much. Thank you.
Thank you for your testimony. Are there any questions from the committee? Senator Whitley.
Yeah, not a question, but just I want to say, as your senator, this Concord School District is very lucky to have you, and I just want to share my appreciation today for taking your personal time to provide this powerful testimony. Thank you.
Thank you. I'm lucky to work there too.
Thank you.
Okay. And I leave this with you.
Okay. You're all set.
Thank you so much.
And we do have a copy of your, hopefully, your written testimony.
Right here.
Good. Thank you. Thank you very much, and congratulations. Kathleen LeClaire, and then after that, Lori Warnock. Who? Yeah, she can bring up her student.
I was going to ask you about that, actually.
How many do you have?
I have 3. If you guys want to come join me. I have 2.
Yeah, just, again.
Well, I'm going to be really quick and let them talk, because I'd rather you hear from them.
Even when them speaking we've had a lot of
Yes,
discussions.
we understand. We've been here the whole day.
I know you have, so I thank you for staying,
So if you guys want to come join me.
Yeah, if your students want to come up, and if they're, what I'd like for them to do is to identify themselves
Yep.
for the record.
Sure.
So,
So my name is Kathleen LeClaire. I am a teacher at Hopkinton High School. I've taught there for 21 years now. So I had something crafted. I'll send it to you as well. But really, I want to give students a chance to speak because for me, that's why I'm here. As with most teachers, I am concerned about some of the things that I've been able to do in class. I've paused sometimes, but it's not about me. It's about students and the preparation that they're going to get for their futures. So I'd like to turn it over to them. So Katie, you can go first.
just, I would like to remind you, I know you all have, it looks like you've got written testimony. Please try to paraphrase it, and when you're done, hand it to Ms. Horgan, and we will all get copies of it. Is that okay with you?
Yeah, that's totally fine.
Okay,
Paraphrase.
terrific.
If you guys could just make sure you pull the mic to you. Yep. All right, is that good? All right, good afternoon. My name is Katie Meserve, and I graduated from Hopkinton High School in 2020, and I'm currently a sophomore at Tufts University. Hopkinton is a town that has an overwhelmingly white identifying population, which is a trend that we see throughout rural New Hampshire. And this means that as students, we are very much within our own racial bubbles, with not a lot of contact with people from cultures that are different from our own. In my life at Tufts, my life is vastly different, as my freshman year roommate lived in Turkey, which is known for its very oppressive legislature, and I currently live with several Asian American and Asian identifying students. Education isn't a place where policymakers get to pick and choose what content is taught based on how upsetting or divisive it may be. The United States history and, unfortunately, current social and political state is filled with cruelty, injustice, and both subtle and not so subtle biases, primarily on the basis of gender and race. It's difficult to talk about, certainly, but it is so important that students are armed with the context that surrounds people that are different from them. It is important that students are able to form their own opinions and are presented with all of the valuable information that is taught throughout teaching race, gender, and sexual orientation in schools. My education at Hopkinton High has shone a light on the experiences that are had by so many others even before I went to Tufts. In my AP English class, I read the book Just Mercy by Bryan Stevenson and learned a whole new side to the criminal injustices in America. I learned of the atrocities committed towards Japanese Americans in the 1940s in my history classes and was exposed to different pronouns and how they can be used in everyday speech. These topics are heavy for a high school student to learn about, but it is absolutely necessary that students are armed with all of the information, good and bad, when forming their own opinions. Teaching history and current events isn't promoting some sort of agenda, it is stating facts and allowing students to interpret that as they will. I know for a fact that the understanding of my own privilege, along with the context to go alongside with the experiences of my friends at Tufts, is due to the exposure that I got through my studies of race, gender, and sexual orientation at Hopkinton. Thank you.
Thank you. Next.
Hi, can you hear me?
Yes, we can.
My name is Mia Richter. I graduated from Hopkinton High School in 2021. I'm currently a freshman at Brown University. I will paraphrase what I wrote. The main point I want to make is that I believe strongly that the problem that the language in HB2 was trying to address is not a problem at all from my experience in high school. I never encountered in 12 years of public school any suggestion that I should feel some sort of shame or inherent moral failing because I am white. Again, like Katie said, our school is overwhelmingly white, and so I feel it is really important that teachers in our school and schools like it be able to have nuanced discussions about these complicated historical topics and engage with multiple perspectives on them, which is what my experience was. More than anything, I was taught to think and argue for myself in high school, not to accept any particular set of beliefs. And then finally, like Katie, I now attend a university that is orders of magnitude more diverse than my high school, and I'm expected to have a certain level of competence around issues of race and gender and class, and I feel very strongly that it is important for students to get a strong foundation in those subjects in high school because they may go places other than New Hampshire after they graduate. Thank you.
Thank you for your testimony. And finally, if you could identify yourself for the record.
Hello, everybody. I'm Hal Stokes, and I am currently in high school. I'm a junior, which I think is sort of unique. I mean, I've been here for 3 or 4 hours, and I'm the only high school student here, which is, pretty cool. But anyways, I think it's a privilege to be here with all of you today, and I want to focus specifically on the word privilege, because in my personal experience, I want to provide an anecdote in which I used that word and was subsequently, I guess, not exactly attacked, but certainly, I guess, scorned for it. So anyways, in a school-sanctioned debate in my economics class over paid family medical leave, I said that it was only for a privileged few that you can have paid family and medical leave. At which point my high school teacher jumped in and told me not to use the word privileged because it was a trigger word and because it made people uncomfortable. I was personally shocked because in my experience in high school, I've never been censored by a teacher before, especially not for a word so rudimentary as privileged. I think it's my right as an American citizen to use a word in the English language in a respectful and essentially unbiased form. And I think it's terrible when words like that are being, taken out of context and are essentially being, not allowed in classrooms. And I want to say, I actually respect this teacher. I think he's a great teacher, and I fully understand what he's doing. He doesn't fully understand the law, and because teachers are confused. And teachers are being harassed in our society and in our school system. In Hopkinton specifically, there was a website by a group of parents that has been targeting our teachers. And I think, in closing, that it's important for you guys to recognize that while we're kids, we're able to make our own decisions. We live in a time when there are crazy ideas out everywhere, and we're really good at sort of understanding what's real and what's fake. And so I think it's important for you to allow our teachers to teach and for you to allow us as students to make decisions on what we believe and what we think. And it's never a good idea to start to censor ideas because it doesn't allow us as students to think for ourselves. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Okay, Senator Whitley and Senator Khan.
Thank you, Madam Chair. I just want to say, again, as your senator, you make your town incredibly proud. We appreciate you coming here today, taking time out. Your voice as students, as the future of our state, as the future generation is incredibly important. And the way that you articulately described your experience and what you want to get out of your education is incredible. And I'm very grateful that you're here. Thank you very much.
Senator Khan.
Thank you, Madam Chair. Thank you all for your testimony today. I think that your reflections on forming critical thinking in high school is important. Some of the letters that we've received have said that isn't something that should occur in high school. Mr. Stokes, I have wondered how high school debate teams or students competing, or how do you have debate without challenging assumptions that some people have? Many might disagree, but it's those assumptions that need to be challenged through the debate process. So I really appreciate hearing about privilege. If I say anything here that you want to respond to, I hope that the chair will let you do so. And Ms. LeClaire, I wonder, in your classroom, have you pulled up short on some of the conversations or assignments that maybe you had in your curriculum?
Did you ask if I had changed them? Is that what you're asking?
Because you and your colleagues feel you've discussed this, and there are some things that you thought were formative that now you're rethinking as I don't want to be criticized.
Yes,
thank you.
These students. The two that have graduated were in my AP language class. Usually in the spring, I do a blog assignment where juniors in that class read a nonfiction book that focuses on some aspect of race, whether it's the history of race, whether it's the justice system and race, education and race. And we aren't yet at that unit, and I am definitely considering whether I teach that unit. It is often a unit that students say is one of the most interesting that they've had, and that the students could speak to that themselves if they wanted to. But what I would like to say is that we trust our students to come up with their own ideas. The thing I tell my students every year is that my goal is to make you a critical thinker. It doesn't have to be that you agree with me. And often I will push back and say, even if I agree with you, Al had this experience, you still need to support your ideas, and they can't be biased ideas. They have to have evidence behind them. And so I will push them, whether they're on one side or the other, to listen to each other, because my goal is to make them critical thinkers, to make them more articulate communicators, and they can't communicate unless they're listening to each other, because then they're just speaking in a vacuum. So that is a unit that I have worried about, I've thought about a lot. I have a substitute if I need to change it, so I've kind of been waiting to see how this law has played out and the impacts that it's had. Because the bounty is certainly in the back of my head. I've been teaching, this is my 21st year. They've all been at Hopkinton. I've had that unit in AP language since I started that course probably 7 or 8 years ago. And this would be the first time that I haven't done it. And again, students have questioned the books. One of the books that we read is The New Jim Crow. And there's students that push back against the claims in there, and they support those ideas with research. And I am totally fine with that. One of the blog post assignments is always talk about the writer's argument. How well do they support that argument? Is it clear enough to you? Do you think it makes sense? Find other evidence that supports that or refutes that. We bring up other aspects of current events. And I think that's one of the things to think about, is that we've talked a lot about the teaching of history, but history is happening right now. And if we don't talk about those topics with students who read about them, who see about them on social media, who experience them daily, we're not preparing them for the futures that they're going to have. Sorry, that was a long answer.
Thank you.
Are there any further questions for Ms. LeClaire and her students? Okay. Seeing none, thank you all very much.
Thank you.
Next, we have Lori Warnick. And then after Ms. Warnick, we have Nancy Brenna.
Good afternoon. My name is Lori Warnock. I'm a resident of Hampstead, New Hampshire. I have submitted a written copy of my very eloquent testimony, which I will not be reading to you.
Thank you.
But I do hope you'll take a look at it.
Oh, we will.
The comment that I haven't heard expressed and that I would like to share is this. The school environment is a petri dish in many ways. There are a lot of things that brew there. One of the things that brews in a school, especially in a middle school, is discomfort. I thought about what you were saying about your children identifying themselves as Republicans and the few Republicans in the room, and I thought, first of all, that can't possibly be true. This is New Hampshire. But I also thought they were comfortable identifying that way, likely because they'd had the chance to bounce ideas off somebody, probably someone who challenged them at home in a safe setting. And that is what school should be for our kids. One of the things that I find most troubling about HB 544 and the RSA that resulted is that it places a higher priority on, it makes discomfort a greater harm than discrimination. And discomfort is where we learn. It's where we challenge our own thoughts. It's where we ask what it is that's making us, what uneasiness that new knowledge can create for us. And that's that critical thinking that helps us to develop and employ decision making. And that's what's so important for our kids. They're going to be uncomfortable about a lot of things in middle school, especially because they're horrible to each other. They call each other all manner of names and judge each other on so many factors beyond race and ethnicity that they have to learn both how to manage that discomfort in order to develop the resilience that we want to see in them. And resilience is something that our children in particular are struggling with right now. And I think by denying them the opportunity to have these conversations in a safe setting, and they do see their teachers as a safe setting to challenge new ideas, by denying them that opportunity, we are working against allowing them to develop the resilience that they need going forward. So thank you so much for the opportunity today. It's been a fascinating process to listen to.
Well, thank you. It always is a very fascinating process with every single bill that we deal with, because we're here to listen. So, but thank you very much. And does anyone have any questions for Ms. Warnock? Senator Gannon.
I'll just be real quick. I never mind my children being discomforted and being in a minority setting where they can argue. They've all gone on to, like the previous students we had, same type schools. Tufts. I have one going to Trinity. She chose between the two. And so my students are critical thinkers, and they never, I was the one probably who doesn't like when they're the only one and the other Republican in the room shuts their mouth because they don't want to be tweeted on all the time. My kids do not fear that. They are not wallflowers who mind it. It's just I was letting, the situation isn't comfortable. And so if, like a critical race theory, if you brought it up, I don't mind it being brought up, but the positions of progressive movement people tend to be to advocate and say, well, you are biased because you've grown up watching, I don't know, the Andy Griffin Show and everyone's white and you just don't see things and there's no way you can understand someone else's position. So they're really just judge you. It's a racist view against some people, which I don't feel should exist. And I don't think the kids should be put in those spots. Though my kids thrive in a challenging adversarial environment and probably are all going to be big lawyers. But
I don't doubt that. I mean, just from what I witnessed of your questioning today, that you are, free to challenge another person's idea. My concept about the discomfort piece is that it's so evident in the wording of HB 544 and the legislation that it spawned, that there should be no settings in which an individual is made to feel comfortable because they are being called a racist because of their beliefs. Frankly, if their beliefs are racist, they should become comfortable with being called a racist. Sure. So that idea that discomfort should be the guiding factor in a conversation or in an educational setting, I think does our kids a disservice.
thank you.
Are there any further questions? Okay, seeing none, thank you very much, and thank you for waiting.
No problem.
Appreciate it.
It was worth it.
The chair will call Nancy Brenna, and then after that, we have Heather Giglili. I don't know. I'm sorry? Giello. Yep, Giello. I wasn't sure.
My name is Nancy Brennan, and I am from Ware. My testimony begins, thank you for taking my testimony this afternoon, but I think we've gone over into this evening. I am speaking in support of SB 304. I am a retired teacher, and I can tell you I loved my job. But I can't imagine teaching today. I feel lucky to have taught in a public high school where innovative teaching methods were encouraged and we were trusted, treated like the professionals we knew ourselves to be. We strove to graduate problem solvers and independent thinkers. Some of my lessons involved creating situations where students were asked to put themselves in someone else's shoes and reflect on how that felt and what they learned in these roles. For my work, I was named New Hampshire Teacher of the Year and given the Governor's Award for Arts in Education. But I doubt I could teach some of those lessons today. Today's public school teachers find themselves mistrusted with bounties on their heads if they ask the wrong question or say the wrong thing. At the same time, parents are free to take money out of public school and privately teach whatever they want their kids to learn. I don't know if anybody here knows of the homeschool curriculum titled School of the West. Write it down, look it up. Their curriculum is based on the concept that the white race is superior. Now, I am not questioning a parent's right to homeschool their kids, however they see fit. But there is something rather ironic, don't you think, about a public school teacher being turned in for teaching what structural racism is, when down the street, their tax money could be helping some parents teach their kids that people of white are superior to people of color. The original so-called divisive concepts bill was folded into the budget and did not get the separate attention it deserved. I urge this committee to think about the effect that bill has on the atmosphere around public education. Do we want our children to learn the truth about our history and our culture, the good as well as the harmful? Do we want them to be independent thinkers who can justify their point of view with facts and strive to make this world a better place? Or do we want them to be little robots memorizing a whitewashed version of our country's history? Please support SB 304 and remove the divisive concepts language. Let teachers teach. Thank you.
Thank you very much for your testimony. Are there any questions from the committee? Seeing none, thank you. Next, we have Heather, and after that, we have Louise Spencer.
I was going to say good afternoon, but I guess it's good evening now.
Yep, it's after 5, and we're gonna.
We're getting overtime, so it's.
We don't get overtime, but our committee secretary, it's been a very, very long afternoon for her, so please don't read anything, please.
Sure.
We're interested in new testimony at this point, so.
Absolutely.
Thank you.
So my name is Heather Giello. I'm here to register my support for Senate Bill 304. I'm a high school English teacher. I teach at Monadnock Regional Middle High School. I'm also the department chair at Monadnock, and I've taught in New Hampshire public high schools for 29 years. I'm also a doctoral candidate at Plymouth State, and I am actually writing my dissertation on the effects, the bill that we're talking about today, the discrimination in public workplaces and education law, has had on high school English teachers across the state of New Hampshire. So we've talked a lot, I've been listening the whole time to people talk and give testimony about critical thinking. And critical thinking is so incredibly essential to education, particularly in English. But the only way students can think critically is if they have multiple perspectives. And in order for them to have multiple perspectives, we need to, as teachers, bring in all sorts of different voices. And so that's where we get diverse and multicultural literature. And so one of my biggest fears, and what I'm seeing when I speak to my colleagues and what I'm reading about other reactions from teachers across the state and also the country, is that teachers are hesitant to use diverse literature, to bring in those voices that might prompt some divisive concepts, or what we're calling divisive concepts in this law. And so the vagueness of the law in particular is causing a lot of fear and a lot of stress among my colleagues. For instance, although the law explicitly states that, and I think you mentioned this before, Senator Gannon, the law explicitly states that historical references to prejudice are allowed to be discussed. It doesn't specifically discuss or mention that current references of those prejudices are allowed. And so I think a lot of that causes confusion for teachers. So from what I'm hearing from my colleagues is that, and I am going to read just this because I want to make sure I get their voices correct. In our curriculum, we discuss topics that connect to current events as well as American and world history, but that has been difficult to do within the parameters of this law because of the anxiety I feel about the possibility that my teaching credentials might be taken away. Another is our most vulnerable school populations, members of minority groups such as people of color and people who are members of the LGBTQA+ community suffer from this law. It is difficult to have conversations around their experiences without worrying that I might lose my license. The law is inherently discriminatory as it denies students the opportunity to see themselves and their experiences reflected in the curriculum. It is also difficult to teach text where we are connecting the text to students' lives while navigating the law. This year, I struggled with teaching The Outsiders and connecting it to my students' lives since I wasn't sure if the law would allow me to discuss stereotypes with my students. And finally, it makes me reluctant to initiate conversations with my students. So New Hampshire's right to freedom law is really fraught with ethical violations and dilemmas that threaten the decades of efforts by educators to create an equitable and inclusive curricula for students. Not only will it likely make it difficult for teachers to meet state standards and national standards that depend on critical thinking, and also multiple and diverse perspectives for reading and writing, and for schools to meet accreditation standards. But it strips New Hampshire students from the opportunity of engaging in rich conversations with their teachers and peers about the world in which they live. Thank you.
Thank you very much for your testimony. Are there any questions? Senator Khan.
Thank you, Ms. Gigello.
GLO. GLO. Just like the letters, I tell my students GLO. GLO.
Thank you.
Thank you.
Gigello. Who is a constituent, and I thank you for being here on time, early, in fact, beat me here, and staying through. I believe you sent us testimony about the qualitative comments that you've collected from teachers as part of your doctoral work. Is that right?
I haven't yet. I'm still working on that study, but I can give you what I prepared today.
Either way, however you'd like to do that, today's testimony or.
And I would be happy. I'm still working on the study right now. I'm in the midst of it, but I will be happy to certainly share my findings.
Yeah,
which should
sounds
be
like the
next
chair is
couple of months.
interested in receiving comments today or after the meeting.
Thank you, Senator Khan. I've already said that we're not executing this bill, and so we will continue to receive comments, emails, letters, whatever you have that you would like to send us.
Sure.
Please do so.
I'd be happy
So
to.
we'll have plenty of time to read them.
Thank you very much.
Thank you. Okay. Next, we have Louise Spencer, and then after that, John Grebe. I think Grebe. Okay. Please, I'd like to remind you, don't read your testimony. We've had a lot today already, and
yes,
we're interested in new ideas. Okay.
Right.
So
yes,
thank you very much.
you.
My name is Louise Spencer. I'm from Concord. I'm also the co-founder of a group called Kent Street Coalition, which is an all-volunteer grassroots advocacy organization. Although I suspect that most of all members would agree with what I have to say today, I am actually here speaking on my own behalf. So I am going to read some things briefly, which is not testimony, but a quote that I'd like to share.
Sure, that's fine.
To my point. So, whites, it must be frankly said, are not putting in a similar mass effort to re-educate themselves out of their racial ignorance. It is an aspect of their sense of superiority that the white people of America believe.
Thank you. That they have so little to learn. The reality of substantial investment to assist Negroes into the 20th century, adjusting to Negro neighbors and genuine school integration, is still a nightmare for all too many white Americans. These are the deepest causes for contemporary abrasions between the races. Loose and easy language about equality, resonant resolutions about brotherhood fall pleasantly on the ear, but for the Negro, there is a credibility gap he cannot overlook. He remembers that with each modest advance, the white population promptly raises the argument that the Negro has come far enough. Each step forward accents an ever-present tendency to backlash. Those are the words of Martin Luther King Jr. in 1967. I raise those because so many who speak in favor of the underlying legislation that was passed in SB 2 and against a bill like SB 304, which I am here to fully support, are very quick to quote Martin Luther King's I Have a Dream speech. The speech, the quote we all know, that I have a dream that my 4 little children will one day live in a nation where they will not be judged by the color of their skin, but by the content of their character. I suspect that if some children were to bring home the first quote, it might well trigger a response under the law. We have to teach the whole of history. We cannot just teach the whitewashed version, the part that's easy for us to hear. We have to hear the good with the bad. And I think it's very illustrative when we look at Martin Luther King's record. Many of the things he had to say were encouraging and supportive, but many of them also were challenging and difficult and made us, or should have made us, and continue to make us very uncomfortable. And we learn in that discomfort. I want to leave the committee with one question, which is think back to your education. Think to the teachers that you learned the most from. Were they the ones that just gave you the ABCs and the facts? Or were they the ones that even when it came from a place of their own deep passion, when you knew exactly where they might stand, and yet they challenged you, they got you to think? That's what makes us grow. That's what makes us learn. You know, these days we can just open a book and we can read things and we can learn basic facts, but we need to be challenged, and that's really essential. So think about your teachers, please, and ask yourselves which ones really made the most impact on your life. So that's my testimony. I thank you. I do want to really thank the committee for so graciously attending to all of the testimony today and making sure that everyone has a chance to be heard, because I know it has been a long day, but I really do sincerely appreciate that. So thank you.
Thank you very much for your comment. That's what we're here for.
Yeah, I'm wondering, I did touch this microphone with my mouth. Is there a way to clean that, or do we need to worry about that? I didn't do it on purpose, I promise.
I have hand wipes, not sanitary wipes. Yeah, hey, moms, it's the mom thing. Sorry, thank you for indulging me for that.
No, thank you, and thank you
I
for,
appreciated that, and so please introduce yourself.
Hey, thank you for-
Again, please, we are now at 20 after 5, and we still have one bill left to hear. So please don't read anything, and try to be as quick as you possibly can.
I will. Thank you, and
Thank
thank you for hearing from all of us. My name is John Graby, and I teach constitutional law and other subjects at the University of New Hampshire Franklin Pierce School of Law. I also direct the Warren B. Rudman Center for Justice Leadership and Public Service there. The views that I am expressing here today are my own and not those of the university or the Rudman Center. I strongly support Senate Bill 304. Others have and will testify about the need for classroom conversations about topics near the periphery of the restraints on speech imposed by the law that we are discussing. I share their views in full. Speech bans targeting controversial topics are rooted in weakness and fear. Over time, Americans have always come to see them as misguided. But I would like to focus my testimony on another deeply problematic feature of this law. The feature to which I refer is legislative authorization of legal action by uninjured persons designed to chill their targets from engaging in lawful conduct. If you follow the news, you probably are aware that the Texas legislature has enacted a law that invites anyone in the nation to file a lawsuit against persons or entities involved in assisting someone in obtaining an abortion after the 6th week of pregnancy. And you might also have heard that California Governor Gavin Newsom is trying to get the California legislature to enact a similar law, though the one he's pushing for is going to target anyone involved in the manufacture, distribution, or sale of certain firearms. Now, at present, many abortions and commercial firearms activity targeted by these laws are constitutionally protected. But the goal of these laws is not to regulate illegal conduct. It is rather to make it too risky and expensive to exercise one's lawful rights. Now, many in this legislature oppose the protection now afforded to certain abortions and commercial activity involving firearms. And many in this legislature would like to see the law change so that states can regulate these activities more freely. But no one in this legislature should support legislation designed to chill lawful activity through vigilante lawsuits, as these laws do. Sham laws such as this undermine political accountability and invite cynicism about the integrity of the legislative process. They disrespect the rule of law. Deceitful government conduct seeking to punish lawful action is the very definition of tyranny. New Hampshire's law is a sham. By its terms, it prohibits discriminatory speech that no competent professional would engage in. But its remedial provisions, which invite any aggrieved person to sue schools and to report teachers to the State Board of Education, seek to accomplish far more. The goal of these provisions is to deter educators from engaging in difficult but essential and entirely lawful conversations about racism, slavery, sexism, religious bigotry, and other forms of discrimination. Earlier versions of the law make this clear. If this legislature wants to suppress conversations about these vital topics, it should enact a law that does so explicitly, and then the people of New Hampshire can judge whether they agree. It should not hide behind a subterfuge. The people of New Hampshire are entitled to honesty and transparency from their representatives. Many thanks for considering my views.
Thank you very much for your testimony this evening, I should say. Are there any questions from the committee? Senator Whitley.
Thank you, Madam Chair, and thank you, Professor, for coming here. You know, I think I'm grateful that we have our preeminent constitutional law scholar providing your assessment of this law, and I think you bring up a different area about the sort of bounty nature, and I think that's a problematic one. And so I just want to say I appreciate that new part coming to light, and I hope my committee members really take that to heart.
Thank you.
Senator Khan.
Thank you, Madam Chair. Mr. Greavy, thank you for coming. Thank you for the insights and your testimony. I don't remember having read something that came to the committee yet.
I haven't sent anything.
Yeah.
So I will.
If you don't mind.
I would like to,
If you don't feel that that's too risky to do.
No.
Please do so. I think you linked a couple of concepts together there that I think were valuable. Thank you.
I will do it tonight. Thank you.
Okay, are there any further questions? Seeing none, thank you, and thank you for waiting.
Thank you.
Next, we have Ann Romney. Okay, I don't see. Jonathan Weinberg. And after Mr. Weinberg, we are going to call Will Arvello. I think that he left. How about Christine Philpott? Just in the back. Okay, thank you. Good afternoon.
Good
So,
evening.
Good evening. Please don't read.
It's different information, I should add.
Okay.
And it's very short relative to other. If I go on a little soliloquy, that could be a little longer.
Okay, well, you have a right to be here, you have a right to speak, so it's just, we've heard an awful lot today.
Definitely.
So.
And thank you so much for being
Thank
here.
you.
My name is Jonathan Weinberg. I'm a member of the Concord School Board. However, I'm here in my capacity as an individual and not speaking on behalf of the board. But I do see Senate Bill 304 as critical legislation for many aspects. Firstly, for helping distill the fear in teachers that they will be reported for merely teaching history. As we all surely know, the group Moms for Liberty, as other people have mentioned, placed a bounty on teachers' heads if they were found guilty of teaching so-called divisive concepts. If this wasn't enough to make educators weary, concurrently the state of New Hampshire instituted a snitch system where parents and individuals could report educators who violated the recently passed divisive concepts legislation. Yet, outside of the legislative chambers, it appears no one can really define what divisive concepts are. Last summer, as a member of the City and Community Relations Committee on the Concord School Board, I represented the board with fellow members at a booth every Saturday by the State House. This created a unique opportunity to engage with constituents and community members outside of a formal meeting setting. As expected, we received many questions about back to school, but the most common questions were about if we taught CRT or critical race theory. One of the main questions I inquired of those asking was, what do they define as critical race theory? Then, individuals would typically say that it is when you make white people hate themselves. But what was even more staggering was when someone said to me, it is basically a new version of slavery. I was taken aback by this claim that critical race theory was slavery reincarnated. I wanted to recommend a book, as we heard from the students earlier, The New Jim Crow by Michelle Alexander, as that provides another view on what a new iteration of slavery is. Yet that would unfortunately fall under the category of forbidden books. Other times, while I was by the State House, people make comments equating critical race theory to Nazi propaganda. As not only an individual in education, but especially as a Jewish person, to hear these comments comparing the teaching of history to a time when my great-grandfather was in a concentration camp is despicable. We live in a state where critical race theory has become an umbrella term for everything it is not. And what is even more tragic is how the state of New Hampshire and the state legislature have only fanned the flames of misinformation as they legitimize the misidentification of critical race theory as either Nazi propaganda or encouraging people to suggest that it is a new age of slavery. This must stop. I urge you to pass Senate Bill 304.
Thank you very much for your testimony. If you could, if it's okay with you, to leave it with Jenny, she'll make sure that we all get a copy, so we'll get the whole thing.
Awesome.
Are there any questions from the committee? Seeing none, thank you very much for your testimony this afternoon. Next, we have Christine Philpott, and after that, we have Dwight Davis. Good afternoon.
Good afternoon.
Good evening.
Good evening.
Yeah.
I want to reiterate appreciation for staying late and for hearing us speak. I'm here to support the Senate Bill 304. My name is Christina Kim Philpott. I have been a public school educator teaching English and dance for the past 15 years. I am also Manchester School District's Chief Equity Officer, but I am here today as an individual in my capacity as a New Hampshire resident, as a mother, and as an educator. I became a teacher to be the adult I needed as a child growing up here in New Hampshire circa 1980s, 1990s. I went to K through 12, so Parker Verney all the way up through West High School and later on to Plymouth. I am a Korean American adoptee. I was raised by French Canadian stock in Manchester, and I'm here to give you also a different immigrant experience, a different Asian immigrant experience. I was educated here in New Hampshire and not under this law, and here I am today. I don't want to belabor all the things that we heard today, so just know I'm not going to read this, but a few points that kind of really stood out for me. I appreciate that the intent of the bill may have been to ensure that all kids could come to our schools and feel safe, right? Feel a sense of safety, belonging. But the outcome of the law is the direct opposite. If we actually want kids to come to our schools and feel safe, feel valued, feel seen, and feel heard, the training that I'm supposed to be giving is what we need. I have changed language. I have revised words instead of anti-racism, instead of anti-bias, instead of unconscious bias. I have changed words in my trainings to ensure that I'm not walking that pathway to breaking the law, that I'm not inviting my teachers to walk that pathway and reiterate that language to break that law. And I've also refrained from giving some trainings. And they're really to create culturally sustaining educational environments for all of our students. And those pieces, really what they're doing is helping teachers understand the cultural backgrounds of our kids so they can better access and better teach our students. I want to speak to a few things when if we're still talking about the advocacy piece, the idea of not advocating for something, for a belief. I respect that, and at the same time, as a teacher, and I think my students, I really cared for them, I loved them, and I think they cared and loved me as well. I could come to class, and if I cut my bangs, they would make a comment about it, right? If I had new shoes, they'd say something. I don't know if you remember SSR, it was sustained silent reading back in the day. Well, we would get a book, you'd read for a half hour straight, it would go all the way through the high school. If I came in with a book in my hand, because I would read with them, of course, they'd ask me who wrote it. Is it a good book, Miss Philbott? Yes, it was a good book. Is that me advocating for Dr. Kennedy's text and all of his beliefs? Am I allowed to bring that book there and read that, even though it is our own book, it is our own choice? So the other thing I wanted to pick up on too is that, like, our teenagers especially, that's why I loved working in high school and everything, because they're going to catch a fraud from a mile away and they'll call you on it. And so when you go into the classroom, for me, the most important part was to be authentic, to bring my full self into that space, because I was asking that of them. When we go into these spaces now, we have to hold back. We don't get to bring our full selves in these spaces. We don't get to be the whole teacher and the whole person for these students. And if I don't get that, then they don't get that either. They've sensed that discomfort. That's not the way that we want to be going into that classroom. That's not the way we want teachers in those spaces. And I will say that I have one of those teacher credentials. I still am certified as an English and dance educator, and I stand here today. One other piece too, this document here actually is that lawsuit for the ACLU, the NEA. I am a plaintiff in this lawsuit. We are making choices not to put my name out in front specifically to avoid death threats and to avoid violence. Another one of my colleagues is here, and when Devin was here, when Ms. Chaffee was here, again, she deliberately, I'm assuming, did not say my name because that's part of the plan. When you were talking about Twitter, my daughter stood here a year ago giving testimony against HB 544. I don't know if anybody here was there when she did that, but they thanked her for her bravery for coming forward to speak out against that. And so if you were, I want to thank you for that. And she did say that whoever did thank her was somebody who is a proponent of HB 544. When she went home, by the time she got home, somebody who is a proponent of 544 and of now HB 2 found her on Twitter, put her name on Twitter, put the name of her high school on Twitter. She had just turned 18, and within seconds, she had several death threats. The language of the death threats was, I would like to see a picture of you with a bullet in your head. I'm good. I've got it.
I want you to understand, probably more than a lot of people, I understand, because I've received death threats as
Yeah.
well. So I understand how difficult they can be, and we're all parents, we all have children, and to have your child subjected to that is unacceptable. But I think that's really part of a larger problem that we have today with social media, and it's unfortunate. It truly, truly is unfortunate. I call them the keyboard cowboys, that they're all brave while they're sitting at their keyboards typing away and threatening people, but
Absolutely.
that's why I think we really need more face-to-face interaction with people, and we wouldn't have that kind of a problem. But I'm sorry to hear that your daughter had to face something like that. For coming here, of all places, and spoke her truth, and
Yeah, and her picture was posted and everything, and it was retweeted, and the death threats came from across the country. Of course, they had deleted those quickly, right? And the person who made the original threat was a 40-year-old woman, yeah, in New Hampshire. Yeah. So I just share those pieces to say, you know, originally it came out as the Divisive Concepts Law, right? And what this law is doing is creating an environment of mistrust. It is dividing us. The outcome of this law is not what people intended. It is if that's what they intended. But it's hurting kids, it's hurting families, it's on the verge of inciting violence. I think, though, I'm in this position in Manchester. It is a manifestation of 3 years of hard work in Manchester with the grassroots organizations called Manchester Proud and the school district. I have hope for the work that we do here in this state. I'm excited to be a part of this. I'm excited to be here. I'm grateful to be here in this moment. But the law isn't helping. It's a deficit thinking practice. What would help, what would address the issue is supporting education, is supporting educators. What does address the issue is providing the resources our communities need to effectively reach each and every student, each and every student. The role of our lawmakers is not to create barriers to accessing education, but to throw open the doors for learning and to give all kids an opportunity to achieve. Thank you for your time. I urge you to vote in favor of Senate Bill 304 and to remove the provisions of HB 2.
thank you very much for your testimony. Is there any questions from the committee? Seeing none, thank you. If you have testimony that you've written down that you would like to submit to the committee, please give them to our committee secretary, and we'll...
I'll clean it up and I'll send it over.
Okay, that's fine. Senator Khan?
Thanks, Madam Chair. This committee, Judiciary Committee, also considers media, violence over the media. And it has come through in a number of different introductory legislation. We have a few this year. And I just want to say thank you for your expertise, your role in sharing a very personal story. And I think we hopefully can call on you again because we need the real testimony of victims of threatening violence over social media to be brave enough to share their stories. Thank you.
Thank you.
Thank you very much. Dwight Davis? That's right, you told me. Okay, I still have to call his name. James Chapman? Good evening, Mr. Chapman. I'm going to remind you, like I've reminded everyone else, please, if you got written testimony, please do not read it. Try to paraphrase as best you can and hand your testimony to Ms. Horgan, and she'll make sure that we all get a copy of it. And please don't repeat testimony we've already heard. Thank you.
Thank you very much. It's just here to trigger my brain, which is very tired. New Hampshire resident, 37 years, registered independent voter. I am not up to date on all the facts the way so many of your expert witnesses are. I just know that I have a lot of friends who are teachers who have told me personally this law has made it a lot harder for them. So I'm here to support 304. I'm from the quiet corner over by Keene, one of those radical people from over by Keene. My personal experience is what I want to talk about. I left the state. I was in forestry. Forestry is my career. But for 5 years, I was a teacher through some strange circumstances. I moved to New Mexico, and forestry is very different out there. They were looking for teachers. I became a special ed teacher. For 4 years, I had an amazing experience in the city of Santa Fe. Felt very supported. Worked with an amazing team of special educators in a small elementary school. I moved back to New Hampshire, did a little bit of logging for a couple of years, and then thought I would be a special ed teacher at a middle school in Cheshire County. I couldn't tell you what the differences are in the two state funding systems, but my caseload was double what it was. Instead of being included in the general ed classrooms with my students, I was in a self-contained room with the lowest functioning kids who needed my help desperately, but it was myself and an aide, and it wasn't satisfactory. So I'm not sure, I can't break it down for you, but being a teacher in New Hampshire, apparently, based on my experience, is already very difficult. I'm not sure what that is caused by, but that was my experience. I wish that a lot more people that are arguing this bill had classroom experience, because I'm going to tell you, I went into teaching thinking really lofty thoughts. I thought, I can do this. This is, you know, I want to influence young minds. I want to have an impact. Well, I'll tell you, I would rather run a chainsaw full-time, all day, cutting down trees, than go back to trying to be a teacher. It's a very hard job. I don't know the details here per se, but I'm going to urge you to support this bill. We have a need to be teaching history as history happened. We need to produce citizens who are aware of the amazing, glorious, stupendous parts of this democracy, but they need to see the warts. They need to see the slaveries, the kidnappings, the genocide. They need to see the whole picture. Teaching is the most important job there is. Teachers are grooming future citizens. If those future citizens aren't compassionate and caring and understanding, why is it that this black family didn't have the advantages? Or why is it that Native Americans are on reservations? Then they will not shape policy in the future. They won't be able, as able to, I was a child in the 60s, okay? I saw all the assassinations as a young kid. And I really thought that we had gotten through racial inequality and poverty and all the things that have been talked about for so long. We haven't. We've got a lot of issues in this country that have to be resolved. The way that we're going to be able to do that is with informed citizens who grew up from being informed students. That's all I have. Thank you very much.
Thank you for your testimony this evening, Mr. Chapman. Are there any questions from the committee? Okay, seeing none, thank you. Next, we have James Morse.
I won't even open the written testimony. Save you from saying that.
Well, sir, if you do have written testimony, please make sure that Ms. Horgan gets it, and that way we will get a copy of it, and a copy will be included in the record.
I will do that. Thank you.
Thank you.
My name is James Morse. I'm the superintendent of schools in Oyster River Cooperative School District. I am honored to be the superintendent of that school district. I've been superintendent for 10 years. I also am a member of our local DEIJ committee. I was on the governor's task force. I was one of the members who resigned in protest over this law. And so what I'll give you is an organizational perspective. Maybe you've heard it. It's hard to know what you've heard and what you haven't heard since we can't be in the room when all the testimony is going on.
So this law passed. I have some incredible teachers. They instantly went into fear mode. They did not know what they could teach, what they couldn't teach. As you know, there's contradictory components to this law. Some of it's vague. Some of it is actually in contradiction to federal and other state law. And so people are confused by this law. But adding to that confusion is fear. So across my system, I have incredibly dedicated teachers, and you've heard from teachers today, and you've heard people praise teachers. I will tell you that they are truly incredible and working very hard in the midst of a pandemic to do what's right for our children. This particular law has put a cloud over the teaching profession in New Hampshire due to the fact that there are actually 3 avenues where a teacher could be challenged for what they're teaching in their classroom, not the least of which is the Department of Education, the Human Rights Commission, and then finally Superior Court. What's the basis of that challenge? Somebody feels that something was taught that was divisive, which is why it has the nickname Divisive Concepts Bill. That was its original intent. When it was modified, that didn't go away. Our teachers are fearful about what they can teach in the classroom. And so as a superintendent, my job was to try to figure out how to support them in the process of reconciling this new law with their teaching practices. I went to the extent of inviting our school's attorney to meet with our school teachers in small groups so they could actually ask questions with clarity related to this law. I had our school district attorney review the law and all the work that we've been doing over the last 5 years to make a determination of whether we were in compliance with this law. And I've never done that before. I spent many thousands of dollars doing that because my teachers needed to be assured that they were not in violation of this law. We developed a template of paperwork so that if any of, and we did this with the teachers, if any of our teachers were challenged, we would be able to compile what is happening in the classroom, address it in terms of this law, and then make a determination because I'm obligated to investigate those charges. Then I'm obligated to report it to the Department of Education. To date, we have not been challenged on this law, but it's only a matter of time until some teacher in our state is challenged. And I listened to the college professor about the whole issue of the soundness of being able to be challenged by an anonymous source and then providing that anonymous source 3 different avenues to challenge our teachers in New Hampshire. I would suggest to you that this law was never necessary. It addressed, I listened to the testimony when it was put forth, and it was all based on critical race theory. The committee at the time listened extensively to an outside state expert. When asked, is the critical race theory happening in the state of New Hampshire? There was no evidence that it was. And I can categorically tell you as a superintendent of schools that it is not being taught in K through 12 classrooms because it is a graduate school law theory. It is not a K through 12 theory that would ever be interpreted at any level in a public school in New Hampshire. So my passion is that you repeal this bill and allow our teachers to be the teachers that they were before it was passed, which enthusiastic and dedicated and teaching the true history of the United States. I grew up incredibly poor, and this country has been great to me. That isn't the case for every person in our country, and we have to recognize our strengths, we have to recognize our weaknesses so we can grow as a country. This law is not the kind of law that encourages growth. It encourages fear. And I'm done. I didn't even look at my notes.
You did great. Thank you very much for your testimony. Are there any questions? Senator Whitley.
Thank you, Madam Chair, and thank you for your testimony and taking my question. Dr. Morse, you mentioned that you were formerly on the Governor's Advisory Council on Diversity and Inclusion. And I know there was a whole set of folks that resigned over this whole conversation and this law that eventually passed. I'm interested in why personally you decided to resign.
I had spent 5 years at that time in Oyster River working with families and staff on diversity, equity, inclusion, and justice, and that was one of the reasons why the commissioner chose me to sit in for him on the committee. When the original version of this law was being promoted, it was contrary to the very principles that the governor formed that working group for. We had spent years going out into New Hampshire, talking to communities, collecting data, presenting it to the governor, and actually the governor, prior to this legislation, was very supportive of the work and helped promote legislation that forwarded the work. But this particular piece of legislation is contrary to everything that I believe as an educator, and that I believe in terms of supporting all children. And so I couldn't stay on the committee, and ultimately I thought the governor was great at the beginning. He was going to not support the bill, and then unfortunately, the machinations of the legislature, it ended up in the budget, and he had to make a decision about supporting the budget or not. It was just something I couldn't buy into.
Thank you.
Are there any further questions? Seeing none. Thank you very much.
Thank you for your patience.
Thank you. Next, we're going to call Dottie Morris. Thank you for waiting, Ms. Morris. It's been a long afternoon.
Oh, it's been a very productive, I think.
Good.
I've learned a lot. And I know you want me to read my testimony. No, I'm just joking. I was always in trouble in school for those kind of comments.
Just please, whatever you do, make sure you give a copy to Ms. Horgan so we will get a copy of it.
My name is Dottie Morris, and I'm a proud educator here in New Hampshire, and I've always worked very hard, and I've been dedicated to co-creating communities where learning could take place. I won't repeat anything. I'll only say that my main concern is that the using the phrase banned concepts. It makes me really nervous, because when you think about concepts and when you think about innovation, innovation is a part of concept. And so when we start to do that, we're on a slippery slope. What I would like to do is just say that I have one paragraph where I just want to move forward. I want to find a way with the students, with the young people's best interests in mind, for us to figure out how, as the adults, how can we model how we can do this? How can we model for young people this process? This process is indicative of why so many of us are concerned about the law as it stands, because these kind of conversations are being interrupted. And so if this is part of our democratic process, how do we create systems where we can teach young people to practice those skills? And by banning concepts, I don't know if we'll get there. So one of the things I want to do is just really, really say, as the elders, and I'm probably older than some of you here, and some of us are emerging elders.
Don't be that sure about that.
As the elders here, I beg us to, once again, to support this bill, SB 304, and come together and find, because the very things that we're saying we wanted to solve, banning won't solve them. The bullying, the empathy that we were able to give when Senator Gann was talking about his child, and when Tina was talking about her child, there's a sense of empathy. There was a sense of pain within me as an elder that I haven't done my job. And I feel like we would be negligent as a society if we don't create opportunities for young people to have these very hard discussions. As an adult, they're hard for me to have, and I've been doing this for a long time. Having these conversations and sometimes being triggered and hurt by them, but at the same time, having an opportunity to grow, because when I was a child, I had people help me navigate these difficult conversations growing up where crosses were burning. I had adults who sat with me and helped me navigate that from, quote, all different walks of life. And it is because of that I'm so passionate about helping young people do the same thing. So I will beg us to try to come together. This is not in my notes, so this is separate. But I would beg us to try to figure out, how do we come together as a civil society here in New Hampshire and get to the real core issue of what's going on and our concerns, rather than implementing something called a banned concepts that does not get us where we want to be. And we've heard it all day today about the pain that it's causing. So I'm pleading for your grandchild or your child or my next door neighbor and all of those students that I eventually work with at Keene State College. And that's all I have to say.
Thank you very much for your testimony. Are there any questions? Senator Khan.
Thank you, Madam Chair. Dr. Morris, clearly you do sensitivity training.
Yes.
I like that exchange at the beginning there. But you also, you help coach college students.
Yes.
Who've experienced, I mean, you in your own life have experienced racism.
Yes.
And yet you have a way of opening up dialogues and discussion without judgment.
Yes.
And it's an amazing talent, and I appreciate it.
Thank you.
But the students that you encounter, they're largely from New Hampshire.
Yes.
They're largely minority students.
Yes.
And I think you might be able to convey to us, in just a short bit here, what are their experiences that they come to college, either fearful that will that happen here, what's happened to me elsewhere?
Yeah.
Yeah, if you can convey some of that.
Well, some of the things, have to do with talking about how they didn't learn certain things until much later because of the omission of certain things within K through 12. And so then when they learn these things, and there's a whole, I was trained as a clinical psychologist, so there's a whole theory and a whole way of thinking about identity development. And so what happens when students get exposed to new material that they didn't learn before, it causes some discomfort, because that's part of the process. And what happens for especially students from underrepresented groups, it's very hard. And so they do need someone to help them navigate the feelings that they're having, the concerns that they have about their future. And so I think that that's important. And on the other end, I work a lot with students who may be engaged in a behavior that's causing harm to students representing certain identities. And what I find when I work with those students, especially those who are, quote, and I won't even use perpetrators, is that there is a sense of shame for what they did, but the shame leads them to altering their behavior, because part of what happens, they don't have a lived experience, but once they hear about another person's lived experience, they start to make some connections in their head. So the idea of allowing students to talk and then having someone help them navigate it from, quote, both ends, I think it really does help us to gain a deeper understanding of each other. And I've, like I said, I've worked with students who held views that were totally opposite of mine. And I know it's possible to keep myself out of the room when I'm working with them, because it's about how do I help them navigate it, not about what I feel or what I think. I could never be accused of forcing my belief on anyone, but more or less helping them to clearly articulate what they believe and what they feel to be true.
Thank you.
Right. Are there any further questions? Senator Gannon.
Yes.
Just since we're talking, nice to meet you, Dr. Morse. Where I think the bill is still good, there's a severability section.
Okay.
So, a lot of the attorneys were saying there's like an error, it's vague. There may be errors. Every bill I've ever written, there's problems everywhere. Lawyers can always find these things. So there is a severability section. And so if any provision is found to be invalid, that can be removed. And that leaves more of the bill. So I think it can be, none of us want to burn books. And again, as you've heard me say a million times, I want you to teach what you got to teach. I want you to read every book any of those books I've seen today were all acceptable to me. I wouldn't have any book that isn't. It's just the advocacy is all we're after. Like you said, you would never like push your own agenda on a student. And I know the teacher in the back who spoke earlier, you people wouldn't, but I have witnessed teachers push agendas. And I think that's where half of the state is seeing, they're under the belief that there's a pushed agenda. And this bill was giving them comfort. I realize that on the other side, it's giving discomfort. And there are things that maybe could be changed, but I think we're going to throw the baby out with the bathwater. I think there's good in here, and there was a good intent. I don't think there was any nefarious intent to silence speech, to silence teaching. I think the intent was to make a better learning environment, and so people wouldn't be, I know one person said you should be discomforted so you feel, but like I said, when other students in a minority political position wouldn't even say anything because they didn't want to be bullied. That's what it was trying to do, because there was no bad intent in this bill, and I think there is good here, and I think we could sever things that aren't good without writing a whole new bill.
Yeah, and I am in no way trying to imply intent, because sometimes I don't even know why I do things, let alone wonder why other people do things. But my question is banning the best solution to getting to the outcome? I just feel like we have that's all I'm questioning.
I don't think the bill bans books at all.
No, it says banning, it's labeled as banning concepts.
It was the advocacy is what the intent, I believe.
But okay, I hear you. Thank you. But I was just saying that once we start saying things like banning concepts, that is anxiety producing, because part of what we're supposed to be doing and part of concept building is about innovation, is about creativity, is about all of the things that we do in education. So that's all I'm questioning.
Thank you.
Are there any further questions? Thank you very much for your testimony. Next, we have Carissa Caro. Not here, okay. How about Vicki Pittman? Okay, you're gonna pass, okay.
I'll email my name.
Okay, thank you, we appreciate that. The last person we have signed up to speak is Mr. McKim.
Wow.
Well, Mr. McKim, I congratulate you. You've sat here through the whole thing.
It's always an honor to close the show.
Yes, there you go. It's always an honor.
Oh my goodness, it certainly is an honor
Mr.
to
McKim.
close the show. Good to see everyone. Thank you so much for your listening to what has been quite a slew of testimony and stories, all very powerful, all very heartfelt, and it's so difficult. Part of me says I don't want to be in your shoes. I wouldn't want to be in your shoes to have to sift through all this, but I'm certainly glad that you all are sitting where you are and offering your knowledge and expertise and time to sift through all of this. So I do have some notes. I'm not going to read everything. I am going to paraphrase, and I'll certainly give my full notes to you for you to peruse. Just by way of introduction, I'm managing partner for Organizational Ignition, which is a management consulting firm which focuses on organizational performance through diversity, and that is the subject of a book that I'll be publishing in March. Book plug. I also wear a number of other hats. I am president of the Manchester branch of the NAACP. I served with pride on the governor's LEACT commission, which spent quite a bit of time talking about this very issue of diversity and how we in our society deal with it from a criminal justice and law enforcement perspective. I also have a national purview as I serve as chair of the Episcopal Church's National Committee on Anti-Racism and Racial Reconciliation. So I try to bring those different perspectives to New Hampshire and to these discussions around diversity. I'm here to support this bill. And I recognize that there are many motivations for the right to freedom from discrimination statute. And I believe that they're all honorable intentions, well motivated. I think, however, that the language of that statute is what I would refer to as a textbook case of where intent does not equal impact. And I think that I'm not going to belabor that because I think you've heard that in droves already here. I will say about that, though, that the confusion that is in the language that makes teachers and public officials feel that they can't say anything about the real discrimination that exists has implications for people of color like me, has implications for women, has implications for people with disabilities, because it negates our experience. Also, I'd say, and I'm not sure this has been raised yet, the perspective of parents, and I know Tina has actually mentioned that, Dr. Shilabot has mentioned being a parent and how this has impacted her. But for many people of color, there is already a distrust of government and public officials and institutions. The language of this statute has, from the discussions that I've had with folks, with parents of color, increased that mistrust. Again, I recognize that the language was well-intentioned. The impact has not been what was intended, I don't believe. I'll relay a story of my own, as I have, as some of you may be aware, provided training on implicit bias to the Attorney General's office and folks in the Judiciary. I had been working with them to deliver this training before the language of HB 544 came out and before the statute was passed as part of HB 2. Once it was passed, I actually said to the Attorney General, I'm no longer comfortable delivering this training that we were scheduled to deliver because of the lack of clarity in the legislation. This was 2 weeks before the Attorney General and Director Malachi, who's here, and Commissioner Edelblue put out their guidance around the legislation. So when the guidance came out, and this is after the Attorney General and I had the conversations, I felt comfortable delivering the training. But I am still a little worried about it, because even though there was a little more clarity in that guidance that it is, in fact, not prohibited that these concepts should be taught and encouraged that these concepts be taught, that is not the language that is actually in the legislation. And so the Attorney General's and that guidance is not legally binding, even though we may in practice feel it's okay because the Attorney General and the Commissioner and the Director said that. So I have a concern about that. I'm going to skip a part of what I was going to say there. So another observation I make about the statute is that there's a difference between equality of stature and equality in treatment. Equality in stature is what we have based our country on from the Constitution, equality of stature. That's different, though, than equality of treatment, how we treat people. And we think we need to treat people equally. The challenge to that is that we are not all on a level playing field. Equal treatment does not get equal access, because there are people who already have disadvantages. There's this great cartoon that I use in my instruction that shows three youths. You've seen that before, right? Three youths of different sizes trying to see over a fence to see a football game or a baseball game, right? And in one of the three panels, they're each been treated equally with a box of the same size to stand on to see over the fence. So the tallest youth can see over the fence. He can see over the fence anyway. The middle youth can now see over the fence. Barely. The smallest youth cannot see over the fence. So that's equal treatment that doesn't work. That same thing happens in our society, and I think that the language of the legislation is based on the assumption that equal treatment is sufficient. And there are a couple of examples in the legislation that I'd like to just point out that bring me to that conclusion. First of all, in section 354.A.31, section 3 states, should not be discriminated against or receive adverse treatment. I'm paraphrasing there because I don't want to read the whole thing, but you have it. This allows white males to say they've been adversely treated if someone from a protected class gets a job over them or gets into school over them, because they would consider that adverse treatment. The second example of this that I offer up is in that same section, that same clause, section 4, which states that that people should not treat members of other identified groups equally. So there's that equal treatment issue again versus equitable treatment. Right. So if there's a way to change the language in this legislation such that those are addressed, I'd be fine with it. But I think that, as has been discussed, the context in which these clauses sit are problematic. And that is why I am in support of SB 304. And I just offer, if I might, a potential amendment. Because I think 304 doesn't quite go far enough in one area to mitigate some of the concerns that have been raised around the current legislation. I would love to see that the languages indicate that not only should no one be subject to civil liability, but also no one should be subject to any punishment or retaliation or any other kind of punishment for discussing these subjects. Because that's what the fear is at this point, that there will be punishment for just discussing these subjects. And I think we need to make a positive statement. I think somebody previously said that we want to have encouragement. And that's what I think that SB 304 does. It replaces this confusion in language which discourages teaching with an encouragement to teach. That's what I think that will bring about equality of stature that I think was intended by the original statute. Thank you.
Thank you very much for your testimony. Are there any questions from the committee?
You could
Senator
indulge
Gannon.
me 30
Yes, of
seconds.
course.
Only because you talked so long about, which isn't a bad thing, but
Sorry.
about equity. So, and you and I are, let's say, I think you're probably way smarter than I am, probably much more educated. But let's say we're about equal. And, right, but you might have had more of an adverse, you've had a hard time, you're one-parent family, you grew up poor, whatever things, and maybe I'm middle class, so I had a little advantage. I'm with you on the fence, okay? So if I give you the bigger footstool, and I take you into Harvard over me, when we're about equal, maybe I was a hair better, but you have had a much tougher time. And I'm aware some of my kids are in admissions at Ivy's. And so I know that they're giving a bigger footstool.
Yeah.
And so that's what's creating part of the fracture in our society, is that all these people who are on the other side, who aren't here today, are saying that they want to be treated equally. And if you give your footstool, much bigger one, to one person, you're treating them not equally. And so then they're not going to get the advantage. You're giving someone else an advantage. So it's a vicious circle. I understand where you're coming from with that, but I have a problem with your whole fence and the footstool, because you're giving someone a huge boost, and then it's in place. It's a zero-sum game. There's only so many admissions at Harvard, right, in Harvard Law. And so if you get in because of disadvantages, which I feel bad for, even though I was a more qualified candidate, you're creating a separation. You're creating people. That's where I think we're getting a lot of the split in society and racism coming from, because they feel it's not equal isn't good enough anymore. So I don't like the whole footstool.
Yeah, I get it, and I would say that there is no such thing as a zero-sum game.
There is when you're applying to a college, though, isn't there?
But there's a bigger picture here.
Bigger picture
So
there.
when I'm
There's a
applying
bigger
to
picture
Johns
here.
Hopkins for medical school, there's 104 admissions, and if they're giving 10 extra bonus points to one person and not another, it's going to create a jealousy, and it's going to be fracture us.
I totally agree with that. It is going to create jealousy.
And fracture us, where I want you to study hard, and you're probably smarter than me, and you're going to get in anyways. So I don't want to give you the footstool, too.
So I'd ask the question, how do we address the inequities that have been over time?
Well, it's over time. So I didn't grow up a slave owner in the 1800s. My people were living in little caves in Ireland, working in servitude and couldn't own land. So I understand oppression and other things. But it's a time, so people have come, they've in advance, and I realize why haven't certain minority groups advanced as fast as others? And that's a whole nother discussion for another day.
Yep.
Anyways, thank you.
Right.
Senator Khan has a question.
Mr. Kim, thanks for coming. Would you agree that part of that bigger picture is that we're trying to prepare people for a healthcare system, and that healthcare system benefits from a more diverse graduate pool that would then serve a wider population?
I would absolutely agree with that. We have to somehow figure out how, and this gets back to Dr. Morris, we have to figure out a way how to address both the systemic inequalities that exist and not penalize those who were, through no fault of their own, have these privileges. We have to figure out a way to do both. We can't just do one.
I agree with you. That's how we have to do that. Thank you.
Knew we'd solve it one way or another.
Sure.
Okay, so thank you very much, Mr. Kim. I appreciate you being here, and thank you for your patience.
Thank you.
We have reached the end of all the people that have represented. You've already spoken. There is never a quick 2 seconds.
Seriously,
Never.
2 seconds. I just want to say.
Now, please sit down and identify yourself for the record, please.
Thank you. State Representative Maria Perez from Milford, New Hampshire. I just want to take 2 seconds to say thank you so much. This is the first time that I'm coming to this committee, and I'm so appreciative that everyone speaks so respectful, and then we all speak without being interrupted. And I appreciate that all of you take the time to listen to us, given the testimonial, even that it's overtime. Thank you so much for staying and listening to us.
Well, thank you, Representative, but this is what we do in the Senate.
Thank you.
So,
thank you so much.
Thank you. So I'm going to go ahead and close the public hearing on Senate Bill 304. Is that person still waiting? Oh, my goodness. Okay. waiting, so we're going to go ahead and do the last bill, and hopefully that really will not take very long. This one is $2.99. There you go. Jimmy, here you go.
She's gonna introduce it. Right? $2.99.
More relevant to you.
Right. You want me on 304?
That's what I'll do. Right in your wheelhouse.
This is going to be. Yep, it's right here.
Good evening. We're going to Senate Bill 299, and the Honorable Senator Carson is going to introduce the bill. Thank you, Senator.
Thank you very much. Good evening to the committee. It's been a long afternoon for us, and I really appreciate you all hanging in there. For the last bill of the day, I'd like to introduce Senate Bill 299 FN, relative to the penalty for escape. And this bill amends the elements required for charging felony or misdemeanor escape. This bill was a request from the Department of Corrections, but I have had a meeting with the chiefs of police, and they have voiced some concerns. So I would just ask all of you to please let's not exec this evening. Some work needs to be done on this. So thank you all very much, and someone from the department is here to talk about the bill.
Thank you, Senator Carson.
Thank
Do
you.
we have any questions for Senator Carson? No, seeing no questions. Thank you, Senator, for your testimony.
Thank you. Good evening. Do you have the sheet? Yes. Lynn Cusack?
Yes.
Please identify yourself for the record.
Thank you, Madam Chair, and good evening to all of you. I know you've had a very long day, and I appreciate that you are sticking with it to hear this testimony. My name is Lynn Marie Cusack. I am the Director of Professional Standards for the Department of Corrections. I am also an attorney and provide general counsel to the Department of Corrections as well. I have submitted, Lissa Massio from our department has submitted the testimony to you. I'm not going to read our testimony. I also have just provided your clerk with the testimony. What I do want to do, and I know, Senator Carson, you indicated that you had talked with the police chiefs. I had a conversation this afternoon while 304 was going on with Captain Ebert, who was here. He was going to testify, but he and I had a conversation about what his concerns were, which I think may be the same as the police chief. So I have a recommendation or an amendment that I'll put forward to you as soon as I tell you why we're here. And this bill was originally brought forward back in 2019, I believe, or 2020, the first year of COVID, when at the end of the session you had the omnibus bill and it never was put forward. What the impact is, or what we were concerned about from about 2015, when 642:6 Roman 3 was originally changed to read the way that it does now, there was a line that was put in there that impacted the New Hampshire Department of Corrections in the ability to prosecute consistently or successfully those individuals that escaped from our facilities. And when I say escape, it could be an escape from behind the walls, those individuals that are behind the barbed wire, or it could be an absconding or an escape from the halfway houses or from our transitional work center. And what changed is, and if I direct your attention to the language of 299 as it originally was, line 9, which is now struck out on the bill, it read, if no physical force was used by the actor and persons other than the actor sustained bodily injury as a result, and no other persons sustained bodily injury as a result of the escape, the offense was treated as a Class A misdemeanor. What prosecutors did with that is said, well, if no force is used, then what's the purpose of really prosecuting this? It's a Class A misdemeanor. We'll have it run concurrent to their sentence. If they're being sentenced for murder, it's a 20-year sentence. It doesn't matter. Well, the consequence of that is there's no deterrent. And people that get out into that halfway house or even behind the walls, if we take, for example, and you may have heard this testimony before from me a few years ago, the escape from Dannemora at Clinton Prison in New York, where let's say that those individuals, after the month or so that they were out, didn't kill anyone, because they did. But when they were escaping, they used no force. They dug their way through a tunnel and came out of a manhole on the other side of the prison wall. If that were to happen in our facility today, that somebody found one of those areas that they could escape and come out through a manhole, I'm not saying that there is one, but let's say there could be, that individual would not be prosecuted for an escape that was a felony. They would only be prosecuted with a misdemeanor. And the same is true for an individual that escapes or absconds from our transitional work center, which we had recently, and the individual was on the run for about 6 weeks. And during the time that they were on the run, they had a weapon that their girlfriend brought them that very night that they walked away. This was an individual who was in for attempted murder, and the prosecutor said, we're not prosecuting that case. It's a misdemeanor. What's the sense? So that's the impact that we're trying to address today. Understanding what I did when we originally put forward the language is I saw it as a three-tiered system, or that's where I thought the legislature was going back in 2015 when they changed the law, that it was a three-tier. We have Class A, Class B, but a Class B only if there was force used. And what I tried to do is break it down and to say, well, there still is three types of prosecution, one for the Class A, one for the Class B, and then one for a misdemeanor. The police chiefs, and I believe the Captain Ebert, expressed concern about the language. If we now turn to starts on line 2, but really is on line 3, the bold, which results or could result in serious bodily injury. They're concerned that that adds an additional layer that they don't need to have. If force is used and somebody is trying to perpetrate an escape, then that force should be a Class A felony. So I'll cut to the chase. Here's what I'd like to do to amend this bill to make everyone happy. We get rid of that language that we proposed, which results or could result in serious bodily injury. Strike that. Then, starting at line 5, we take the strikeout out, put that language back into the bill. But on line 5, we add the offense is a Class B felony, comma, regardless of whether force is used, if the actor was on parole, subject to bail, all of that, the rest of that language. Then we, down where the sentence that is most concerning to us, that sentence at line 9, we add language in all other cases if no physical force was used. So those cases that come about as a result of an escape or an absconding from one of our halfway houses is clearly a Class B felony. where force is used. If a weapon is used, then it's going to be a Class A. And then we strike the rest of that language that we've suggested that you put in. I think that gets us to a consensus with the police chiefs and with the state police.
Thank you for your testimony. I would ask you to put that together in an email and send it to me, and we'll get it drafted and we'll send it out to the committee. So thank you for doing that. We really appreciate it. Are there any questions for Ms. Cusack? Okay, seeing none, thank you very much.
Thank you for your time.
Appreciate it. Before we adjourn, I would like to thank all of you for hanging in there for what was a very long afternoon. And it was, you know, we met yesterday, we met today. So I just appreciate all your hard work and for you being here. And I just want to thank you. And we'll keep moving. And I would also like to thank our staff, Ms. Horgan, our secretary, Mr. Lehman, our attorney, and we have Mr. Bossy here, who is helping us navigate people along with Mr. Vatz. So again, I want to thank everyone for making this go so smoothly this afternoon.
And thank you, Madam Chair, for making everyone feel welcome.
Oh, well, thank you. Okay, is there a motion to adjourn? So moved. Moved by Senator Khan. Is there a second by Senator Whitley? All in favor say aye. Aye. All noes? Those who want to spend the night? Okay. Committee here is done for the day. Thank you.
Yes, thank you all.
Thank you, Grant.
Yes.